for the list. Yes.
One on two.
Today is not the mentioning day. Mention on Monday.
Hello, may I participate? It's very urgent matter. This matter already mentioned before your lordship by my senior, and this exam date is 14 September.
Yes.
Kindly keep it on tomorrow.
What is the urgency?
Under revision of subject by the School Service Commission.
What is the urgency? Tell me.
Hello, kindly.
Mere exam date will not suffice. What is the urgency? Tell your senior to mention at 2. Yes. Yes, call the list.
Item number 1.
I have recorded the submissions of all the parties. Then in paragraph 27, I have held that Regulation 38 prescribes a retired employee of KMDA can commute up to 1/3 of pension, but keeping parity with the norms relating to commutation of pension applicable in case of the state government employees. KMDA employees are also permitted to commute up to the extent of 40% of pension, though same is not provided in Regulation 38. An attempt was made on behalf of KMDA by placing reliance on order dated 5th February 2010 issued by Officer on Special Duty KMW and SA to offer an explanation that enhancement of limit of commutation of pension from 1/3 to 40% was not automatic but based on approval of the state government. However, it could not be demonstrated that steps were taken for amending or modifying said regulations of 1988 as required under Regulations 52(1). Mere approval of the state government as disclosed in order dated 5th February 2010 pending adoption of provisions relating to commutation of pension in connection with Regulation 38 cannot satisfy requirement of Regulation 52(1) of said regulations of 1988. Principal Secretary Finance Department in the impugned order which was communicated via memo dated 3rd January 2014 while rejecting the proposal of KMDA for restoration of commuted portion of pension of the pension of the petitioners stated a policy decision is required to be implemented, but state government did not take any policy decision for extending benefit of restoration of commuted portion of pension in relation to pensioners of statutory bodies, undertakings, local bodies, etc. But such finding of the Principal Secretary appears to be erroneous. Retired employees of Kolkata Municipal Corporation are getting benefit of restoration of commuted part of pension, and in this regard an office order dated 20th November 2010 issued by Chief Manager SRSC and pension is annexed at page 160 of the writ petition. Now, ultimately, I have directed, then I have considered the judgments relied upon by the respective parties, and in paragraph 33, I have directed in aforesaid conspectus impugned letter dated 8 October 2009 issued by OSD and ex officio Deputy Secretary to the Government of West Bengal and decision of the Principal Secretary Finance Department which was communicated via letter dated 3rd January 2014 of the Assistant Secretary to the Government of West Bengal Finance Department Law Cell are set aside. Consequently, concerned respondent authorities are directed to restore commuted part of pension of the petitioners by 4 weeks from date. Respondent authorities are directed to release arrear pension to the petitioners which is payable due to revival of commuted part of pension from the date following the date of completion of 15 years to be reckoned from respective dates of commutation of pension by the petitioners by 6 weeks from the date of communication of this order. Arrear pension shall carry interest at the rate of 8% per annum from the date full pension on revival of commuted part of pension is payable to the petitioners till the date of release of same.
My lord, this is my lord, the scope is only for the petitioner.
Yes.
My lord, the scope is restricted for the petitioners only.
Yes.
তোমার নামটা ঠিক মেয়ে তো ওর কাছে আছে ও বললো আমি লিখতে লিখে চিনি না তো তোমার ছবিও লিখে দিচ্ছি
এটা সার্ভার করে দিন।
গ্রেটফুল
Item number 2.
This is covered by Shompa Ghosh judgment.
Yes. Yesterday I mentioned the matter.
Yes,
Yesterday I mentioned the matter before my lords. Now, my lord, I submit, my lord, that I applied for the post of assistant teacher in life science. Now, my lord, judgment of the Supreme Court.
whether your name is appearing in the list dated 30th August,
That's
yes or no?
yes.
If it is yes, then the issue is covered by Shompa Ghosh.
My lord, kindly just for a second. I say, my lord, I would be only, my lord, taking 2 minutes time of my. My lord, kindly consider that, my lord, so far as the list of 30th of August 2025 at page, my lord, 391 to 423 of this particular, my lord, bunch of documents, your lordship will be pleased to find that the name of the petitioner, my lord, was included in serial number 1387 at page 415 in the volume 3.
395, yes, volume 3.
Yes. Now, just one. That
List starts from 390.
391.
Where is the name of the petitioner?
Page 415. Page 415.
Yes.
1387. Now,
1387.
1387.
That
serial
page is
number.
not there.
Page 450.
1372. Then 1401.
At the right hand side.
Is 24.
1387.
Yes.
Now, my only contention is, my lord, kindly see that the provisional, my lord, admit card at page 381.
Yes, Mr. Bhattacharya, in other matters where I have decided in some of the matters, admit cards were cancelled, withdrawn.
In so far as my case is concerned, had it been a case that my admit card is cancelled and withdrawn, then I have no case. I cannot say anything. Kindly
Yes,
see, that's the reason I just want to
The
indicate.
submitting admit card is cancelled.
My lord, I did
Similar issue I had to deal. I had an occasion to deal with this issue in the last week, and in that judgment, I have all the issues were considered. Where admit card was issued, but it was subsequently admit card was dropped, and yes, Shompa Ghosh. Admit card was not given effect to, and I delivered a judgment, and that was upheld by the revision bench.
Sir, I have only one thing to say, that my lord, so far as my name is concerned, your lordship will be pleased to find that my lord, from page 367.
And moreover, this list has been published in terms of the order of the Supreme Court. So therefore,
No,
we
I
are
am only on the point,
it is
my
not
lord.
in a position.
Another thing, just I point out that uh, if it is not cancelled, why he has come? Number one. Even if it is not cancelled, when he will enter into the center, he will not be allowed, or he or she will not be
No,
allowed.
I am not on
It's
that.
cancelled.
I am not on that. I am only on the point that in the list of tendered candidates, my name appears.
Hmm.
Therefore, I cannot say that my
Yes.
name does not appear. This is an
Now,
I would be-
I have held that this list cannot be
I
tinkered with
only
at
say,
this
my
stage,
lord, my
since
own,
the list has been
I
published in terms of the order of the Supreme Court.
yes, I
And
don't,
there are other issues which are gone into in connection with paragraph 363(4) of the judgment dated 22nd April 2024 passed
Yes.
by the Honorable Division
my
Bench.
lord, I
There are three
just,
categories were delineated, and those categories are considered, and this court
No.
held that these are not the exhaustive categories,
Categories
these are the
are-
probable categories,
yes,
and there might be other
No,
categories.
Yes.
that
So
is
therefore-
also, I sorry that I couldn't point out, able to point out. This, I have explained, it is not only these are the only others. Paragraph 41 of the Supreme Court judgment, earlier it was made clear.
my lord, just once,
Paragraph 41 of the judgment.
What does it say?
Paragraph 41 of the main judgment, kindly see. Hey, একটু বার
3rd April, 3rd April.
3rd April judgment বার 41 না 41 আছে হ্যাঁ নাও paragraph 41 of the judgment 41 da? I have shown your lordships two categories, that the number etc the statistics
OMR mismatch.
and OMR kindly come no যা বলছি দে না yes 41. The claim that the data on the 3 hard disk shows no interpolation and is consistent with the data in Mesh's data's context resolution comprehension. These issues highlighted in both the improved judgment and our findings clearly point to large-scale manipulation and tampering with results, including rank jumping, discrepancies is marked, the issuance of appointment letters to candidate not on the panel, and appointments made beyond the panel's ability. My lord has again very clearly spelled out that in your lordship's this judgment, this Shampa Ghosh's judgment, very clearly it has been spelled out by my lord. But it was earlier there, but it has been very clearly, it has been spelled out. Now it is.
only one thing, I just last time submission, I will not be making anything, I will not make any more submission.
Just a minute.
Yes, sir.
It's also a pertinent observation.
Yes, yes. That point I have taken before the division bench. That day I missed it. I was saying that this chart and this chart, this has to be taken into consideration both the ways. Now,
It
again,
shows the magnanimity of the or extent of illegalities.
yes,
which,
that's a
was
paragraph
there.
41. Yes, paragraph 41. Then very clearly spelled out in summed up, rather I put it that it has been summed up by your lordships in your lordships judgment.
Lord, I just only say one thing.
Actually, this is the problem. I had to face it before the division bench also. Then I said, this is also wrong.
For a second, Srinath, kindly come to page 367. Just 367. This is a report which was filed by the West Bengal Central School Service Commission.
চট করে আমি
ওখানে কত
বলেছি,
হচ্ছে?
তোমরা
11?
যে যেদিন তুমি আসতে পারলে
আচ্ছা,
না,
এতে
আমাদের,
আছে,
ইয়ে
এতে
করতে
যেতে হবে।
সেগুলি না, এই ম্যাটার
এতে এক জায়গায় সব বসে থাকিস না কিন্তু কেউ উঠে চলে যায়।
Yes, yes, yes.
Page 367. In volume 3. This is a report in the form of affidavit affirmed by the chairman of the West Bengal Central School Service Commission. Now kindly come to the page 378. This
That is in
continuation.
connection with MAT 85 2023.
Yes, no, I am saying that kindly see page 378. Why I say the list of candidates against whom no action was taken, and here my name appears in serial number 23. Shauli Mukherjee.
Serial number
23.
370.
No, 23.
After that, all of them.
378. 378. Item number 23.
No, that is much before the division bench judgment and the.
Because here it is indicated against whom no action taken yet.
It is prior to the division bench judgment.
Division bench judgment, yes.
I say, these are the things which I can
And
say.
whether you are permitted to continue till 31st December 2025 as a teacher, then what steps you did take?
Your lordship may kindly consider.
Only the so-called untainted teachers who were found to be not tainted, they were permitted to continue till 31st December 2025 as teacher by the in terms of the order of the Honorable Supreme Court dated 17th April 2025. What steps you did take, Mr. Bhattacharya, when you are not permitted? It goes to show that you are being treated as tainted. And I have considered this aspect in Shampa Ghosh.
I cannot make any more submission as I told you.
Any other matter under the same category? From item number 2 to 6?
Yeah, no, that is a different, yes, like yesterday's matter. That is there. That Millard order may be passed.
Appeal was preferred as
Appeal
a
was
junior-
preferred, but
then
appeal
I
was,
had to
appeal was
sit.
ma-
I had to sit late after recess in
Appeal-
order to put signature and
no, that's the, but,
and put it
that-
on the server.
but appeal was made infructuous.
Yes.
I think your lordships have understood it.
Yes.
And this is also a very kind attitude of my client chairman. I must. When I had a talk with him in the and he or she got the admit card also.
So only one matter today in today's urgent list. This comes which relates to 30th August 2025 list. No other matters.
No.
No, this is
See, item 5.
Yes.
No,
Not
item
50.
5. But other matters, my lord, kindly pass that also. Just whatever the submissions I have made, school service, etc., keep it there.
Yes.
And then but tomorrow, my lord, kindly do not interrupt. Please. Otherwise, it will be very impossible. Up to today, I have agreed to them that no, please.
Last moment. There is
Now,
a
this is very difficult. Very difficult. But he is very nice, I must say. Well, I said, you see, desire of the single bench, desire of the division bench. When it was mentioned, division bench also indicated. Well, all right, madam. All right. I don't have anything to say. Only the infrastructure. But I must say, my lord, I have a wish. I have a wish that have a good luck of them. All these untainted teachers should come. And let it be finished, then I will tell you.
Yes. Other matters. Mr. Bhattacharya, you need not elaborate because issue is already dealt.
no, that's the reason I yesterday told myself.
So you should not have any grievance. That matter is not heard at length.
No, your lordship.
Since the issue is already no more recentica, so far this court is concerned. Yes, another matter.
Item number 5 below.
Is also five.
No, tainted is not.
I don't have two. No, item. This is item number 2. Yes. Give your appearance. Yes.
Disable candidate lordship. disabled candidates has been covered by the Supreme Court judgment. Lordship, if your Lordship kindly,
Your name is appearing in the tainted list.
Lordship.
Where is
But-
your name? Page 87, that is the list.
Page 88, Lordship.
Serial number?
The serial number is 255, your Lordship.
Yes.
Now, your Lordship kindly come to the Honorable Apex Court order, paragraph 48, Lordship.
Dated, order dated?
Or-
3rd April.
Lordship. Third-
Paragraph 14,
Paragraph 48, 48,
48.
Lordship.
Yes.
May I read, Lordship?
Just a minute.
At 49, your Lordship.
Do you have a full copy of 3rd April 2025 judgment? Last page is missing in my bunch.
I have
Only last page is required.
from iPad will. I will give
I would
you.
prefer hard copy. Just
Hard copy is there.
yes, it is there in the hard copy. If you have any soft copy, it is there. If you have hard copy, anybody has the hard copy
360
from paragraph
or Mr.
48 onwards.
Mr. Bhattacharya's brief 360. That ঠিক বলেছে স্যার? Disabled কেন এবার করে?
Yes, now, according to your interpretation of paragraph 48 and 49, that all disabled candidates should be permitted.
be
Mr.
permitted,
Bandyopadhyay, come to page 40, paragraph 48 and
Can I
49.
read this or may I read it?
Come to paragraph 48 and 49
That's the same.
of 3rd April.
Yes, ma'am. 48%.
48.
Lastly, we address the case of disabled candidates. Our attention has been drawn to one such case where the impugned judgment held that the appointee, Mrs. Somadas, shall be allowed to continue on humanitarian ground. Somadas' case was considered as
Carved out.
while we will not interfere with the, we will make it clear that other differently able candidates will not be entitled to the same benefit.
Please go on reading.
Same benefits as would contradict legal principles and the rule of law. However, in consideration of their desirable disability,
Disability.
these candidates will be permitted to continue and will receive wages until the fresh selection process and appointments are completed.
You are working?
No, the disabled candidate mentioned in the previous paragraph will be allowed to participate in the fresh selection process. Is there.
Yes. These disabled candidates mentioned in the previous paragraph, candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required with age relaxation and other concessions. Similarly, other candidates who are not
Have
specifically.
you made the application?
Lordship, the page number.
Now, the point is application.
Have you applied for?
Lordship,
In terms
I
of the
applied, admit
recruitment
card was
notification dated.
Admit card was issued.
issued, but simultaneously it is cancelled, Lordship.
Where is it? Paragraph কোথায় আছে দেখ?
Page 86, Lordship.
My lord, would your lordships do one thing, subject to your lords?
Because
Pass an
Supreme
in-
Court permitted all disabled.
Just pass an interim order for the timing. For the timing, pass an interim order. We have to read again. Pass an interim order, staying that cancellation, and he or she, whatever it may, should be allowed to sit in the examinations.
Because paragraph 49 is very clear. It says disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required with age relaxation and other concessions. Similarly, other candidates who are not specifically tainted will also be eligible to participate in the appropriate age relaxation. In our opinion, such direction would fair. So, in one hand, not specifically tainted and all disabled. It is clear from paragraph 48, 49.
ছেড়ে দে তো, অত for the timing, pass an interim order.
Yes, yes.
But it's
Let,
better.
let him or he or she,
কোথায়
he.
বলছে যে পরীক্ষার সেন্টার
let him appear.
অ্যাডমিট কার্ড কোথায়? জাস্ট টেল মি কোথায়?
Admit card as page 86.
এটাকে কাজ করতে বলবো। Admit card, according to admit card, and cancellation, according to admit card, he will be allowed to sit in the examination. Cancellation is, if any cancellation, that would be stayed, and matter would appear after in the month of November. We will see to that. We have to. I have to apply my mind for the timing. Let him sit.
Yes.
And also one thing,
And wish you best of luck. That's much I can tell you. For all untainted candidates, I just wish their best of lucks. And one thing, I worked for you for one night full with him.
another
We are hearing so many criticisms, so many, but I tell you, my lord, I tried to make some elbow space for them. And you have seen the rules itself.
এইটার একটা সেপারেট অর্ডার হবে আগে ফার্স্ট এটা একটা
একটু বলে দেবো কালকে যেন বসতে দিই।
তাহলে বেরিয়ে যাবে ওই পার্থভট্টের যে রক্তটা ফার্স্ট আইটেম
কোন সাবজেক্ট কি?
subject philosophy.
ফিলোসফি, গুড সাবজেক্ট। কি ছেড়ে দেন না, ওটা দ্যাটস নট দ্য মেজর ফ্যাক্টর। ফ্যাক্টর ইজ দিস, then why did you not allow him to? That's not the major factor. And another interim order, although he has not prayed for, I will say in its favor.
Yes.
That your lordships will pass that order. Just he has not placed this case to that level, but after 14th, he should be allowed to continue in his service.
Salary,
Salary and the service.
Yes.
Otherwise, because another question will come up after 31st December. That's the reason I'm saying. I think your lordship has guessed it.
So let him be permitted to
Is
continue.
it will be your lordship's order? Don't do that. And at the time of final hearing, regarding the balance, your lordship
Yes,
will
that will be
decide.
considered.
ঠিক আছে, আর কিছু আছে? ঠিক আছে, ওদের অ্যালাউ করে দিও। তো হয়ে গেছে, বলে দিচ্ছি, আগেই জজ সাহেবকে বলে দিচ্ছি। হ্যাঁ, বলে দিচ্ছি, অ্যালাউ করে দিতে বলে দিচ্ছি। বড্ড দেরি করে সব এসছিস, 4 আর 6 দুজন আছে। হ্যাঁ, 6 অ্যাপ্লাই করেনি? তুই অ্যাডমিট কার্ড পেয়েছিস? 6 হ্যাঁ, না তাহলে হবে না, না তাহলে হবে না। তুই তো আমাকে,
Female, Mr. Bhattacharya, female candidate.
তুমি অ্যাপ্লাই করেছিলে? ওই হলো, তুমি কত নম্বরে? 4 কে আছে? 4টা লোক কি হয়েছে তো? কি হলো, 5 হলো না। তুই ক্যান্ডিডেট অ্যাপ্লাই না করলে আমি কি করতে বসছি? সে তো 9-10 এর। এত দেরিতে কেন আসছে? এত দেরিতে হলে অ্যাডমিট কার্ড দেবো তো। অ্যাপ্লিকেশন ফর্ম কোথায়? অ্যাডমিট কার্ড না না যাচ্ছি আমি যাচ্ছি। দশ সাহেবকে দিচ্ছি না তো। যাবো দাঁড়া, এটাতে একটা ঝামেলায় পড়ে গেল। তাই করো না তো না। চেঞ্জ অফ সাবজেক্ট হলো তো, অ্যাডমিট কার্ড পেয়েছো কিছু? নো, several candidates will be considered.
এই শুভেন্দু অ্যাড করবে তো whereby paragraph 7 whereby according to the petitioner she was kept no whereby এটা wherein petitioner's name featured at serial number 22 in a list and in a list At that material point of time, as it appears that Commission published such list in connection with candidates of classes 9 and 10, or in connection with first state level selection test 2016 within bracket classes 9 and 10, close bracket, containing names of candidates against which no action was taken. Stop. এইখানে প্যারাগ্রাফ 11 এর পরে একটা অ্যাড করো। After the judgment was delivered by the Honorable Supreme Court on 3rd April 2025 in civil appeal arising out of special leave petition within bracket civil number 9586 of 2024 within bracket State of West Bengal versus Boishakhi Bhattacharya within bracket Chatterjee and others, close bracket. And taking note of the observations made in paragraph 41, the document which is relied upon by the petitioner, which is at page 378 of the writ petition, ought not to be given credence. Stop. Stop. This court finds it apt to quote the observations of the Supreme Court, observations of the Supreme Court as contained in paragraph 41 of the judgment dated 3rd April 2025 colon dash 2025 below colon dash বলে এই 41টা সেট আউট করে দেবেন। ঠিক আছে, প্যারাগ্রাফ 41। এখানে হেন্স দ্য রিট পিটিশন স্ট্যান্ডস ডিসমিসড বা এই জায়গাটা লিখে রাখ। ইয়েস, yes, please place your own matter ধরো। এসো, এটা আলাদা অর্ডার হবে, অ্যাড করো। Matter is heard in presence of the learned advocates representing the petitioner and respondent authorities. Stop. Grievance of the petitioner is inclusion of his name against serial number 255 in the list dated 30th August 2025 issued on behalf of West Bengal Central School Service Commission within bracket for short commission quote unquote, featuring names of tainted candidates. Stop. Where is the document in support of your disability?
Page 19.
Page
19. 19.
19. কি বলছিলাম? হ্যাঁ হলো, তারপরে কি বলবো, ওটা তো ঠিক আছে, তারপরে কিছু বলিনি। It is submitted on behalf of the petitioner. এটাও কেটে দাও। Learned advocate representing the petitioner submits that petitioner is a candidate. Petitioner is differently abled candidate, and in support of same, a document at page 19 is relied upon, wherefrom it appears that petitioner is suffering from 60% disability. Stop. It is also submitted that petitioner participated for class 11 and 12. Petitioner participated in first state level selection test 2016 within bracket classes 11 and 12 and was selected under as person with as differently abled person and was appointed on being recommended by the commission in the post of assistant teacher for classes 11 and 12. Stop. Next paragraph.
One thing just
In support of
one thing. Can you come to page 20?
20.
20. He didn't get the employment on disabled quota earlier 2016. This
Is not a disabled candidate.
no impanel category OBC B.
Page
Page টা কত? 20.
Where is the recommendation? Your recommendation?
Page 21. OBC B.
But you are not selected as disabled candidate.
There was no seat of disabled candidate. Vacancy was
No, but you
No,
are
OBC
applied as OBC B category candidate. Paragraph page 20 and 21.
No, disabled quota was there na?
Impaneled category OBC B.
OBC B, not as a disabled. Somago's case was said to be disabled.
PWD category. Person with disability. But you are not selected as disabled candidate under the category of PWD. How your case can be considered based on the observation of the Supreme Court in paragraph 48, 49?
that has not been clarified. This is the only physically able
Only
candidate.
that in 2016 selection process,
He
you
is
participated as
disabled
disabled candidate. Or under not as disabled, you participated under PWD category.
No, Lordship. He was appointed in the category of OBC B. This is true, Lordship. But this is true, Lordship. There was no such vacancy of PWD at that time, Lordship. Now, one vacancy is there for physically disabled candidates. This time, in the fresh notification.
Then you have to-
But as per the order of the apex court lordship,
But
physically-
this disability certificate shows he is suffering from 60% disability.
Not 60%, because of 60% one doesn't get
Because-
it.
Yes, as you are pointing out in reference to page 20 and
He
21.
got it OBC category. Now his case was not anywhere earlier that he was disabled candidate. Now I understand the.
That's why his name is included in 30th August.
That's right,
2025.
exactly.
And he has not been permitted to continue.
Permitted to continue. Otherwise,
This is the reason
Lordship,
that he has not been permitted to continue,
but
where you should have shown the application which you was submitted in connection with your participation in 2016 selection.
kindly
process.
do
Okay,
one
Lordship,
thing.
because
Madam, kindly
my
do one thing. Excuse me, just a
Yes,
suggestion.
yes, yes.
Kindly keep it for tomorrow.
Obtain instruction.
Kindly keep it for tomorrow. Let me take.
Obtain instruction. Yes.
If it
If
is,
he is disabled, he
If
participated.
if anything can be done, I will see to that. That's much I can. But on this, I cannot.
Come back.
Keep it
tomorrow.
tomorrow. Keep it ভালো করে এটা করুন। আগে
Take
এটা-
instruction, Mr. Bandyopadhyay.
I will tell you. But now what I am seeing that is difficult. Keep it for tomorrow.
এটা ওকে দিয়ে দাও।
পাঁচ আগে তোমার আগে মামলা আছে তো 5 আছে 4 না কার কার আছে 3 4 আয় আয়
কোনো রাখো তোমার কাছে প্যারাগ্রাফ 41 টা
কর
তো
তিনটে বার কর এটা
একটু সাজিয়ে দেবো এটাকে দেখো বুঝলি? আগের অর্ডারটা ওই একই ভাবে করা হয়েছে।
কি আছে সব ঠিক আছে
একটা ম্যাটার, ওয়ান ম্যাটার।
ওটা এখান থেকে কোন
Or that item is item number 6. That disabled candidate.
5
Not today. Simply not today.
ঠিক আছে আমি তো বললাম না কালকে রাখতে
Well, record an order.
Yes.
Item number 5, record an order. Matter is heard in presence of the learned advocates representing the petitioner. And Bandyopadhyay, learned senior advocate representing West Bengal Central School Service.
assisted by Mr. Vishnu
West Bengal Central School Service Commission has prayed for accommodation to obtain instruction. Whether to obtain instruction as to whether petitioner petitioner participated in first state level selection test 2016 within bracket classes 11 and 12 as
এটা কি আছে
person with as differently abled candidate or not. Stop. Next paragraph. Next paragraph lists the matter under the same heading for further consideration
কোথায়
tomorrow, comma,
কোনটা কোনটা আছে
12th September 2025. Next.
Item number 3.
not appearing no 19 no that's all right but here the 3 persons are entitled to get I mean that covered by your lots
Persons are coming. Maybe no, that I do not permit. They should have filed a separate writ petitions. The subjects are different.
subjects are, no
Then-
what is the difficulty Miller this is
Subjects are- there is a difficulty. No, if subjects are different, there is a difficulty in passing order.
Para 4 in one paragraph, 6 line malad.
No, I could understand if the same subject conversion you want, that instead of a subject X, I want to be treated as subject Y. But if different subjects are there, why 6 candidates have joined together?
Subject matter is same, that's only.
no subject matter different subjects are there
Yes,
you do
subject-
one thing Mr. Just I am suggesting you place for petitioner number 1 rest please listen to me now bhai I am all the time do not take me as your enemy then listen to me you lordship will give you file it tomorrow it will be maybe taken up for 50 but there are one difficulties one difficulties I am saying so that he can cure the difficulties that is you are saying about the subject that in that subject you have not annexed with any documents of the PG 3 persons are there is no subject there is only 3 are cleared and 3 are not cleared. You check it up.
Yes, yes.
Ultimately, when it will come,
If my lord, I want to change of the subject. Because of that, my lord,
Not I, we.
as my lord, as my lord.
so far, my lord, your losses can.
Get the court fees also, my lord, for all.
Not the court fees. Question, not the court fees. My lord, may I?
Whatever, my lord.
Only one.
My lord, it's upon the court, my lord. In page number 6, my lord. In page number 6, sir, document.
By two,
Court will also find it difficult to pass order.
highly enough to come tomorrow.
Against separate writ petitioner, separate orders are required to pass. From which subject to which subject?
Kindly see para 4 in the block portion.
Oh,
Nothing else. If whatever the my lord's desire, whatever the my lord's desire. And it is just one line order. My lord, kindly see. In respect of petition number 2, the correct subject ought to be the philosophy, but inadvertently psychology. In respect of petition number 3, correct subject ought to be English, inadvertently education. Actually, what happened, my lord?
You may draft your petition in this fashion,
Yes,
but court
as
cannot
my lord
pass
did.
order in the same fashion.
As my lord did. As my lord did. My lord.
no, this cannot be done in this petition because I have to argue in what is there, my lord. 3 persons, according to the pleading and the documents, they even live as that they are entitled to get that protection of your lordship. But so far 3 persons are concerned. He could not satisfy that he has acquired the qualification of the education, the category where he wished to
Whether
go.
that those candidates having respective educational qualifications or not.
Yes, the 3 persons are not there. 3 persons are there. Therefore, this is a
Who are those 3 persons?
3 persons are 2, 3, 5.
It might not annex the all mark sheet.
No, unless you annex the marks.
But the fact is that thereafter in the route there are verification. If he is not satisfied with subject, there is a
আরে ভুল তো যখন আমরা করি তখন তো তুই বাইট দিস আর এখানে তুই ভুল করে এসে আবার অর্ডার চাবি অর্ডার চাবি কি করে
আপনিও take care of that না
আটে কি হচ্ছে
Yes, where are the applications of 235? Online applications of 235.
online after page number 51 is for the petitioner number 2.
Just a minute.
I just referred to
This is the difficulty, you know. This is number 2. In case connection with petitioner number 2, you want to be treated as a candidate of which subject?
philosophy, my lord.
Subject applied philosophy.
no subjects
Psychology, my lord. That is the difficulty, my lord. What happened?
applied for psychology.
So, my lord, inadvertently.
No, you have applied for psychology. Now you want to change my lord, one.
I applied for psychology.
Yes,
But he is a philosopher. No. So that's why my lord's order or
My lord,
the order
my
was
lord,
that
kindly see. One is by me. That's a different thing. Kindly see.
by mistake.
One of the principles, even the Tej focus case in 5 constitutional bench judgment,
Yes,
last
yes.
judgment,
Yes.
after the date of application, last date of application, you can't do anything.
My lord already
Now you cannot change.
patent error, my lord.
No, patent, you cannot change it.
My lord already passed this order, my lord.
There was a rejection order, etc. That's a different thing. You can't do it now. Tej focusের judgment দাও তো tej focusের judgment দাও কালকে তো আমি অতটা শিক্ষিত ছিলাম না আজকে একটু শিক্ষিত হয়েছি yesterday I was not so much learned
থাকো
$1565 principles have been laid down. That's the latest constitutional bench judgment, Miller. Cannot do it.
Have a right, Shankarsan Das was considered, have a right of consideration, not beyond.
No. Now here it has been said that's the day. Last one is that
And rule of game should not be challenged in the minutes.
No, that's right. But the last date has to be taken is the date of application, last date of application, qualification.
But I have passed on.
No, but no, I am, listen, Malad, only one thing, excuse me, Malad. So far, one, kunta bola, 1, 3,
Mr. Bhattacharya, where is that order which I have passed yesterday?
1, 3 and 1, 3 and 1, 3 and
1, 4 and 6.
1, 4 and 6. He have annexed the documents. I am not objecting.
No, those are the cases where Mr. Bandyopadhyay, a candidate suppose not having B.Ed training qualification within the cutoff date. After the cutoff date, that is acquired.
No,
It
no,
is
no.
not that.
This is
It's
not
a
B.Ed.
mistake. It's a mistake. I have held it's a bona fide
No,
mistake.
no, let him satisfy with the documents. He is having that PG degree.
Yes, that's why I am considering one as you have submitted
Yes.
in case of 3 candidates, not
Yes, yes. That is all right. That is all right. That
2, 3 and 5.
2, 3 and 5.
Already, Malad, I have the document regarding.
No.
Malad,
File separate writ petitions.
Yeah. Yes.
Yes, petitioner number 2 separate writ petitions. Petitioner number petitioner number 2 is page 51. It should be philosophy, not psychology but philosophy. Yes.
Yes, Malad.
Then
Petitioner number 3 it ought to be
page.
DJ Koris, how they can be a teacher? They're so irresponsible.
53.
53.
Instead of education, it
No, this is admit card is annexed.
yes, obviously.
But
Admit card as well as the online application. Page number 53.
53. Yes, 53.
Instead of education, it ought to be English.
Urpita, just a minute.
Are you sure they are untainted? They should have tainted.
Bengali.
They are unable to give money.
Bengali.
Money was given by you.
86 to para 86.
Malad,
86.
which one, Malad?
25,
Pradeep.
24, 46.
This is the difficulty, you know. You are not in a position to apply this.
Must be kindly similar.
No, Malad.
Dibba versus
Bengal.
Indian of India.
Bengal, there is no such Bengali,
Yes,
Malad.
paragraph
Page number 55.
The rules clearly mandate, as has been held
Page
in
number
Gaurav
50.
Singh, any mistake, omission, negligence cannot be condoned so as to extend the deadline for production of the documents.
No.
Neither the office manager nor the rules. But let me
Page
see,
number
but I
55,
am
that's
not
not-
pressing on this point because it's a different scenario. We are doing it, it's all right. But if this is the type of mistakes, how they can be a teacher? What bona fide means? Since day before last
Malad,
this
page
week,
number 55
we
is
are
that
seeing
subject is not Bengali. Geography.
Page 53, Bengali.
the Supreme Court
Page
is order.
is education, Malad. My medium is Bengali, but the subject is education.
Then
Malad 55, geography. It would be environmental science.
petitioner number 5.
What is the document?
Petitioner number 5 is agriculture and agronomy.
Agronomy document কোথায়?
58. Page number,
Petitioner number 5.
page number 58.
কি দেখাচ্ছে 58 দেখো 58
Application form.
that's an application form. Where is the document, supporting documents that he has got the PG degree there?
No, you have indicated in 3 matters there are documents.
There are documents. This
Yes.
Yeah.
4 and 6.
Court
Only
is
this-
considering those 3 matters.
that
3 cases.
that are admitted. That are admitted. 146. 146.
Yes.
আমরা বলে এটা কনসিডার করছি
1,
তোমরা
4
বলে
and
consider
6.
করছিস না।
Petitioner 1, 4 and 6.
কি?
Is 2, 3 and 5.
This is not there. 2, 3 and 5 have
No credentials. 1, 4 and 6.
1 লাগিয়েছে।
You have made a mess of it.
Malad.
Separate petitions should have been filed. That is the main difficulty. You know, you see the wastage of time.
Malad. They are petitioner. Otherwise, it is
The wastage of time.
multiple.
Otherwise, same orders could have been passed in 6 other matters. By 5 minutes, it could have been disposed of. All the matters. But you will not here follow the procedure.
They are Unemployed.
No, that is unemployed, that is
Okay.
not the issue.
They're unemployed.
Also, you have to consider the predicament of this.
Untainted or fresh candidates. So
Unemployed, you multiplicity of the proceedings.
I could
Consider
understand that the
multiplicity
same
of the
mistake
proceedings.
from Bengali to English or English to Bengali. That is not subject that candidate-wise different subjects are there.
One kindly pass order, one procedure, one plan.
Why you have done this?
It will work. I know a similar thing. They just miss the. There is a scrolling mistake, nothing else.
Hmm?
Kindly see that.
No, but you find that the difficulty code is saying.
কত নম্বর?
That's why page 6 and 7, it will be just page 6 and 7. It is mentioned. Page 6 and 7 in my petition, it is clearly mentioned. Just one line. Page 6 and 7. Page 7 clearly mentioned.
Who are the candidates which you are not disputing?
Petitioner number 1, 1, 4 and 6 I am not disputing.
Other document is also with me, Mala.
No.
As
Come up with the petitions.
Yes, one I have noted wrongly based on 2, 3 and 5. Take me to the relevant
page number
documents of
47.
1,
Page number
1,
47.
4 and 6.
Page number 47.
47.
Yes, Mala. That is petitioner number 1.
ওখানে কি হচ্ছে রে?
Instead of political science,
Yes, political science.
physical education. It ought to be physical education. Document is valid. তারপরে কোনটা?
Physical education. Then
Petitioner number 4,
4.
environmental studies. Page number 55.
Matlab, with your lordship's name, I just my junior would be there. Matlab, same thing is item number 6 also. Oh, 17. Oh, there is. Acha. Honorable in this matter.
4, 4, 4.
55. Instead of geography, it would be environmental studies.
We don't know. It disabled to instruction. No, that's 60% of the world. No. Huh?
Geography, environmental science.
Yes. Environmental studies. Subject name is environmental studies.
দিনে কি আছে?
এটা 3 চলছে।
একটাই?
না, মিডিয়াম
কি কি?
ইস্যু করতে হবে। ঘরেতে অ্যাপ্লাই হয়। ইন্টারনেট অ্যাপ্লাই হয়। কানেক্ট করে কত রেডি করে
Number 6 page.
Just a minute. 1 minute.
দীপান্বিতা রয়, দীপান্বিতা।
Where is petitioner number 6?
Number 60.
60.
Yes. Education ought to be math.
Education PG, yes.
Ought to be mathematics.
পুরো ভয় বলতে এসব এরকম ভুল আছে। এটা কি ধরনের মিস্টেক? Really, what type of mistake it is? Completely different. It is a mistake. How they can be a teacher? Every day they will commit mistakes, students will rectify them.
But they made 2 applications. The last application was rejected by the
কি 19 কি করেছিল কেন কোনটা কোনটা তার তো আমি এগ্রি করলাম এগুলো কি মিডিয়াম চেঞ্জ না সাবজেক্ট চেঞ্জ কোনটা সাবজেক্ট চেঞ্জ এটা কি করে পিটিশনটা মেইনটেইন মাই লর্ড দিস পিটিশন ইজ নট মেইনটেনেবল somewhere is medium change somewhere is subject change
it's all subject. No?
Subject.
কিন্তু বলি 4 নম্বরটা
এটা 3 চলছে
ও পরেরটা সরি হ্যাঁ
I am considering only in respect of 1, 4 and 6.
Fine.
All are subject change. How you have done this, Mr.
4 নম্বরটা
Shamim, Mr. Shamim, how you have done this? Subject, different subjects, then subject as well as medium.
No, no. There is no such.
not in this case, next
Not
case.
in my case, man. That is separate case.
Political science on to physical education মানে how they can commit a mistake I do not understand. Psychology have become philosophy and education has become English.
By the land advocate
আপনি করলে চাকরি থাকতো না
representing the petitioners.
না না এদের কথা বলছি একটা ভুল
Petitioners
করতে
that while submitting online application forms inadvertently petitioner number 1
in my candidature if I have given it that my candidature as people
petitioner number in
nomination paper was not accepted.
stated no, I have passed order, similar order in connection with subject day before day.
Yesterday
Day before. Where is that order? It is in connection with medium of vacancy.
yesterday was subject wise na yesterday was the order was
Yesterday I passed an order.
yesterday
Yesterday, which was appealed against.
yes
এটা বার করে দাও তো এটা।
we appeal but not
বার করে দাও। এইটা নয়।
জজ স্যারের কাছে কি আছে ফাইল কি এখানে আছে ও বনশ্রীতে
কালকে
yesterday was subjection prior to that was medium change
Yes. Last week it was medium.
medium change up to 9-10 they are good only medium change and 11-12 more matured subject change
Subject.
oh, another 2 days tomorrow today and tomorrow then now every fight is in the Supreme Court now go home.
I am recording your objections, which I have recorded in yesterday's order.
Yes. That otherwise you know. That but everything will be done. My lord, address would be changed. Change of address. Earlier it was Kuchbihar. In that case, Jalpaiguri was a here the Mednipur, Birbhum, the Act 4 আর 6 যেটা বললি সেই অ্যাড্রেসটা আলাদা করে দিয়ে দেন। Well, I am giving the kindly keep this blank. My junior is giving the document so that from to what that will be. কাগজে লিখে দে অ্যাড্রেসটা লিখে সেন্টার I mean the center. এখানে তো সেন্টার চেঞ্জ নয় এখানে তো সাবজেক্ট চেঞ্জ in that center শুধু center will be same. Oh sorry, there may be change of center. Because of the subject change of center, we have to change the admit card.
First act, first act. বলে দিলাম তবে পেন একটু দিলাম তো এসো পারবো না কারেকশন petitioner numbers 145 submitted applications in terms of recruitment notification dated 30th May 2025 being memo number so and so পেয়ে যাবে কেন
না না সেটা প্রুভ করতে ছিল তারপর তো আমাকে ধরতে হয়ে যাবে
1 4 petitioners number 1 4 and 6 বললাম তাই তো 1 4 and 6 1 4 and 6 5 now submitted applications in terms of recruitment notification dated 30th May 2025 being memo number so and so inadvertently in the online application forms which were respectively submitted by the aforesaid petitioners comma petitioner number 1 again subject applied for quote unquote were submitted by the aforesaid petitioners against subject applied for quote unquote petitioner number 1 stated political science PG instead of physical education physical education PG
Yes.
physical education PG
রাত্রি 8টা 9টা নাহলে
comma petitioner number 4
কি আছে তোর
stated geography PG instead of environmental study PG and petitioner number 6
বাচ্চা
stated education PG instead of mathematics PG.
বাচ্চা আমি জন্মাইনি
Stop.
মানে আমি
Petitioners by instituting this writ petition have prayed for direction which would permit them to participate in the ensuing written test scheduled on 14 September 2025 as candidates of different subjects which are not indicated in their respective online applications. Next paragraph.
কতটা চলছে কি নাম ছিল ফটোটা কি আছে
As aforesaid. Rahul?
আলাদা আলাদা করে নাম দেবো কি 2 to 6 একবারে দিয়েছি 2 to 6
No point in
In this case, no representation was made. When representations were made,
Petition number 1, my lord, on 20th August, page number 65.
65. 65 on what?
4 at 68.
Seven.
they are not in-service candidates.
Yes. Yes. Wait.
এইখানটায় আবার চেঞ্জ হবে, বুঝলে, স্পেসিফিকেশনটা লাগবে। আচ্ছা, on paragraph 5 টা আবার লিখুন। On perusal of the materials available on record, it appears that due to inadvertence at the time of submitting online applications, petitioner number 1 stated that at the time of submitting online applications, it was stated by the petitioner number 1 that, or it was stated that petitioner
और कोई একটা দিয়েছি নম্বরটা স্পেসিফিক ইনস্ট্রাকশন লিডিং ই নেই, লিডিং ই নেই, ছয় হচ্ছে আমি বলছি, আমি দিচ্ছি
petitioner number 1
হ্যাঁ
stated he was a candidate of political science PG, comma. Petitioner number 4 stated he was a candidate of geography PG, and petitioner number 6 stated he was a candidate of education PG. Okay. Stop. Stop now. Though stop ta koro na. Though they were having postgraduate qualifications in physical education, environmental study,
and mathematics respectively. So, such এই অবধি চেঞ্জ করলাম, বুঝলি? এখানটা একটু দেখে নিই, চেঞ্জ such facts go to show. Such fact go to show that there was bona fide mistake on the part of the aforesaid petitioners in submitting online applications while offering candidature under respective subjects. Stop. Albeit submission has been made by Mr. Bandyopadhyay, learned senior advocate representing the commission, that arrangement can be made for the petitioner to write examination by attending office of West Bengal Central School Service Commission at Short Lake in Kolkata on the scheduled date, that is 14 September 2025. But it appears that petitioners are staying far away from the head office of West Bengal Central School Service Commission. And at this stage, if petitioners are compelled to attend the office of the West Bengal Central School Service Commission for writing examination, that would create hindrance. That would create hindrance to them. Stop. তারপরে করো, taking note of the aforesaid aspect, concerned authority of the West Bengal Central School Service Commission is directed to permit petitioner numbers 1, 4, and 6 to participate in the written examination scheduled on 14th September 2025 by treating them as candidates under the subjects physical education within bracket PG, environmental study within bracket PG, and mathematics within bracket PG. And not political science PG, geography PG, and education PG. Stop. Commission is also directed, concerned authority of the commission is also directed to issue admit cards to petitioner numbers 1, 4, and 6 by September 2025. Next paragraph. It is made clear that aforesaid directions are confined to petitioner numbers 1, 4, and 6. Are confined to petitioner numbers 1, 4, and 6. Stop. So for petitioner numbers 2, 3, and 5 are concerned, it is contended on behalf of commission that supporting documents showing their respective educational qualification are not appended to the writ petition. Therefore, similar directions are not passed. In respect of petitioner numbers 2, 3, and 5. Stop. However, this order shall not preclude them to file writ petition on the self-same cause of action with better particulars. Next paragraph. Writ petition stands disposed of.
Parties to act on the server copy of this order duly downloaded from the official website of the school. Don't file joint petition. It would be convenient so far court is concerned. Don't file it. Because others are waiting in the queue. Tomorrow I will not permit anybody, but don't file. No, no. এটা একটু দেখে নিও, হ্যাঁ, ওইভাবে সাজিয়ে দিও। Sorry. Next.
Item number 4.
That is today is the last day.
Tomorrow keep it.
Oh, sorry. What is the application date? Sorry. No further. Yes, any other matter?
Item page 42 is the order passed.
But the page 42 is the order passed by my lord.
Change of medium, single candidate.
Yes, same order may not be.
In math subject. Petitioner,
Where is your application, online
my
application?
lord, page 37, my lord. My lord, medium of vacancy applying for, instead of English, it will be, my lord, Bengali, my lord. My lord, petitioner earlier filed a writ application in respect of class 9 and 10, my lord. Page
It is
42.
medium of vacancy applying for.
But page 42 is the order passed by my lord.
Instead of English, it should be Bengali.
Bengali.
In previous order, it was Bengali to English.
No, English to Bengali in respect of 9 and 10. Same petitioner.
Oh, same petitioner. Petitioners sat on 7th and she will again
11th.
on 11th. Yes, where is the order, Mr. Bhattacharya?
Page
42.
Page 42.
Paragraph 3, page 43.
This is classes 11, 12.
11.
চেঞ্জ না, ওটা আরেকটা আবার কেন্দ্রের কাজ করতো না, এটা করছে না। ও আমাদের কাছ থেকে কেন্দ্রেরটা দিয়ে খোঁচাখুচি করে লাভ নেই।
Who is happening for the state? You are for the state. Where is the admit card?
My lord, page 38, my lord.
বড় টানা
খুলে যাবে, খোঁচাখুচি করতে গেলে তুমি কিছু পাবেই না, খুলবেই না কোনো ফাইল।
Same order. Dispute. That I have made.
Item number 6. 6 cannot be allowed. According to the pleadings in the writ petition, apparently, there is no document evincing the fact that he has applied for class 11 and 12. 9 and 10 she has already sat.
Correct. I have to check it because according to my instruction, that has not been annexed. The doctor says that to take up tomorrow. I should try my level best. Otherwise, my landlord assist.
Tomorrow I will not take up any matter. Last day, tomorrow is the application date, and not only this, where is the time?
But in that event, can you take two?
And one matter has also already been kept, 5.
Your lordship, for that should try my luck, my lord. If I possible, otherwise, my lord, no limit can be granted.
There is no document
And at least in the writ
support of the
petition,
statement, in support of
not
the
a,
case
not
made
even a
out
statement is there.
My lord, what happened?
that whether the petitioner applied for classes,
That
classes
statement is
11.
also not there.
What happened? Then be frank, being officer of the court, in terms of the order of the Supreme Court, we have applied twice. Because in first 9-10 months, we apparently
Show me, show this court that you have applied in terms of 30th August 2025 recruitment notification for classes 11 and 12.
lordship. But
No history is required.
would the lordship place that connect to? If possible, otherwise, I don't know.
No past history. Court is hearing these matters for last 2.5 months. Court knows everything.
I'll keep it tomorrow. I try. If I fail, then no relief can.
Tomorrow, then on Monday. You take it. It was mentioned yesterday. I have allowed mentioning. Matter is kept under the heading urgent motion. You are not ready with the matter. So very well. Let it be on Monday.
Can I try my right? One matter, you should fix. Otherwise, my lord, I cannot have an issue.
Well, tomorrow.
My land.
Tomorrow.
Otherwise, my lord, no issue. Okay.
Otherwise, it will be dismissed with cost.
In that way, I am surrender because lordship to withdraw the
আর কোনো
application.
এই ক্যাটাগরিতে আছে?
In that
This
case,
is 6.
trying this application if a lordship form.
শুভেন্দু ওই দুটো লাস্ট অর্ডারটা এক্সাক্ট কিছু নেই, আগের অর্ডারটা একটু মিলিয়ে করে নেব।
My lord, তারা আমি withdraw করি। যদি আপনি বলেন যে অক্টোবর না আমার চেষ্টা করব।
not today, কালকে
Yes.
Item number 7.
Yes.
Lordship, the recognition letter which has been issued by board, there it has been written without financial assistance. But your Lordship, we have not found in a record any undertaking given by the school authority. That we have not found. Even we are unable to find the recommendation letter of the education department. But there was an order of this court. The recognition was given by an order of this court.
Whether that order is annexed to this petition?
No.
Impugned order.
No, there is no impugned order.
Impugned order is 16th April 2025
Yes.
by the Deputy Director. Where is the impugned order?
That is not page 116.
116. Oh, this is the order under which this recognition was.
Yes.
If I may say, the background is that from the very inception, there have been a series of education, but even after this, in all stages, state has said that we are not recognizing this. We would not give them recognition. It was the consistent stand of the state. They ultimately went out to the Supreme Court, remanded back, single bench, division bench. This order indicates that Coordinate Bench of the Court in 2009 had directed, irrespective of what state says, the board was granted liberty to consider this and take a decision, irrespective of what state says. So the question of state giving any recognition, giving any aid, or allowing any aid does not arise, because this court had granted the board the liberty to take an independent decision. Board could not have granted any decision with regard to the financial aid.
Your Lordship kindly see
That's the
Kindly takes the page 4.
I'm concerned about that.
Just a minute.
They said that it is
Just wait.
Page 4 of this order.
That is my love, impugned order 116. It is only cancellation was made that it is private.
Then the issue is to be decided on exchange of evidence.
Lordship.
There is no scope for passing any interim notice. Matter is heard in presence of the learned advocates representing the petitioners, state respondents, and West Bengal Board of Secondary Education. Stop. In the writ petition order dated in the writ petition memo dated 16th April 2025, issued by the Deputy Director of School Education, West Bengal, is assailed, whereby prayer of the school authority to grant financial aid was turned down. Stop. Was turned down. Next slide. On perusal of this memo dated 16th April 2025, this court finds validity and legality of said memo is required to be decided on exchange of affidavit. Next paragraph, let affidavit in opposition to this writ petition be filed by 4 weeks or filed by 2 weeks after the ensuing puja vacation. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Parties shall be at liberty to mention the matter before the appropriate bench for hearing.
after the time fixed herein above for exchanging evidence. No, you can't take it back. You can take a order to Next.
Item number 8.
But last one. You will please to short for a report from the School Service Commission. They are
Yes, report.
Volume 3,
Do you want to file an exception?
can you look into the report on paragraph?
I am asking you whether
No,
you
but I
file an
think
exception.
not required. They have admitted in the report that yes, we have. I can see paragraph, page 5, paragraph.
Yes, Doctor.
Did not dispute the writing at the bottom of the reason. So, question of admitting, it was already admitted. It is the secretary who has given a note because the officer who gave the hearing passed a reasoned order that you did not have the
In service candidate and she was getting higher pay scale, therefore she was not eligible.
The secretary gave the note that there are similar matters pending. Based on those matters, it will be decided how to treat these candidates. Now, since the matters which were before the court the orders were passed petitioner wise, it was not given in the guidance form that all candidates will get. That is what we have stated in our report. That is paragraph 3. And onwards, we have taken it down that at the candidates 3 and 3, due to this writing and yet not being given the similar message, then the question of delay. Because interviews were held in 2021 and 2022. So on that day,
And this is not a 10% matter.
no. And this is page 5, paragraph G on G and H.
What direction Honorable Court passed in similar other cases?
Permit them to appear in the intent. That is annexed to the. Even when the last option, June, in the month of June, you also permitted certain candidates to participate in the verification process. But you know, passed in month of 2020, in year 2024.
ঠিক আছে
In-service candidate lost a job. Now that's why delayed petition is filed. Because at this stage, what can be done? Because
Consider my
today you did not participate in the in connection with first SLST 2016. Upper primary, you did not participate in the interview.
No, I'm not allowed in the interview.
So you could have pursued your remedy then and there.
But they,
Now the selection process is on the verge of completion. 8 round of counseling was over on 1st of August 2025. Today, if whether court can direct the authority to start interview again for the petitioner.
Kindly consider only one. They have not cancelled my.
Why you did not pursue your remedy in 2022 after you are not permitted to participate in the interview?
Kindly consider these two facts. Firstly, I was very much in.
Give me that order, similar order I have passed in all other matters.
Another matter, you are permitted to appear in the
That is in a different context.
counseling process.
That is in different context.
In that matter, the in-services candidate were permitted to appear in the interview. I was not allowed, but the School Service Commission allowed them to participate in the interview. And secondly, my candidate was not cancelled. They said we will consider it later.
But interview was over. You did not pursue your remedy. In 2022, you have filed this petition in 2025.
But yes, absolutely. But
seeking a direction for holding interview when this entire selection process is on the verge of.
They are not cancelled. They said that my candidate will submit the result of the writ petition. The writ petition disposed of in September 2024.
Can you see the representation of the office or the candidate of the after grievance, the candidate was informed as per this case. Though it is coming in 2025,
The other writ
that I
petition.
requested consideration. I was called for hearing on September 30, 2021, but was later informed that my test could not be conducted.
That is in 2022.
Yes, after the grievance hearing. So the candidate cannot say that I was unaware. That is
Writ petition, which was mentioned in the rescind order, disposed of in 2024. In 2024.
It was filed within time.
That may be, but the
You are working in 11, 12 or 9?
9, 10. Untainted, and last Sunday I have also appeared here. In the rescind order, they said the fate of my application would be determined on the basis of the similar writ petition. Similar writ petition disposed of in 2024 itself.
এই এসো, it is also submitted, এইখানটা চেঞ্জ হবে, প্যারাগ্রাফ 4, হ্যাঁ, is also submitted. Then raised grievance for the grievance redressal committee, which was disposed of redressal before the grievance redressal authority of the West Bengal Central School Service Commission, within bracket Forsyth Commission, and same was disposed of video order dated 30 September 2021. Stop. While rejecting the contention of the petitioner, it was stated in order dated 30 September 2021 that as per norms, candidate cannot apply for the post in same or below pay scale. Therefore, petitioner's candidature was not entertained. Stop. Consequently, petitioner was not permitted to appear in the or in personality test. Board is party. Who is for the state?
Yes, ma'am.
এখানেই রাখবেন, এখানেই রাখবেন। টাইমটা চেঞ্জ করুন। It is also submitted on behalf of the petitioner that she was that her prayer was wrongly disallowed by the grievance redressal authority of the commission. Video order dated 30th September 2021. And it was endorsed in the said order dated 30 September 2021 that similar other matters were pending before the Honorable Court, and fate of those matters And fate of the application would be determined on the basis of those matters. Next paragraph. It is submitted by the other similarly circumstanced candidate. Similarly circumstanced other candidates are permitted to participate.
It's only those who were repetitions.
It is submitted on behalf of the commission that similarly other candidates, similarly circumstanced other petitioners who approached this court were permitted to participate in the interview, which was held in 2022.
Yes.
Which was held in 2020.
Issue decided in 2024.
However, petitioner was not the however, petitioner did not approach the court. Neither, however, petitioner did not pursue remedy after order was passed by the Grievance Redressal Authority of the Commission on 30 September 2021. Next paragraph. A representation was preferred on 30 May 2025. After the order was passed, after the judgment was delivered by the Honorable Supreme Court, dated 3rd April 2025 in Boishakhi Bhattacharya Chatterjee Supra. And when petitioner realized that she lost job. However, from the said representation dated 30 May 2025, it also transpires that petitioner was aware of the decision of the Grievance Redressal Authority of the Commission, which was taken on
30th September 2021.
which was taken on 30th September 2021. Meanwhile, First SLSC 2016 upper primary is on verge of completion, and 8th round of counseling was held on 1st August 2025. Stop. Next paragraph. If today এইটাকে অ্যাড করুন এটাকে পুরো অ্যাড করে দিই এই পার্টটা উপরে একটা দিয়ে দাও in terms of previous order. A report in the form of affidavit is filed on behalf of the petitioner, on behalf of the commission, and same on behalf of the West Bengal Central School Service Commission, and same is taken on record. So, learned advocate representing the petitioner submits. Learned advocate for the petitioner submits that petitioner is not willing to file an exception to this report. Next.
I can only record only one thing, but in their report they have filed
next matter
order, my lord. But the issue has been decided in 2024.
Yes.
Whether they will be entitled or not.
Yes, please call the
record
next
this thing only, my lord.
Huh.
But kindly record this portion only.
Please call the next matter.
Item number 9.
General transfer millers. The last occasion, school authority did not apply in spite of service. Call for a report from the DI.
Yes, report. Now, petitioner is not a single teacher in the subject.
Total 3 teachers.
Petitioner is not a single teacher in the subject. There might be 500, 1500 students, but how many teachers are working? That is not been disclosed.
There are 3 geography teachers.
No, but there is another aspect. That is, if pupil-teacher ratio does not permit your transfer on the ground of distance is not permissive. So why the number of teacher? How many teachers are working in the school? Why it has not been disclosed in the report? 15 roll strength is 1500, but petitioner is not a single teacher in geography. But how many? What is the pupil teacher ratio? File an additional report.
May I just submit one thing? Rule 6 says that the grounds of not giving NOC this departmental proceeding that is not there. Then if the subject the resultant vacancy becomes 0, then they can give no.
No, that is also a relevant consideration. It is 8 September.
Amended rule. Previously, it was not there. Now, grounds have been incorporated in Rule 6.
Consider the number of subject teachers and roll strength.
Yes, subject teachers. So, subject geography, but there are 3 teachers and 100 not becoming 0. Even then, it can be considered.
Read clause C in its entirety. Consider the number of subject teachers
and roll strength.
Yes.
If resultant vacancy of school in particular subject becomes 0,
comma,
or not commensurate with roll strength. Subject.
What is the roll strength? 1:40. The pupil teacher ratio should be 1:40. If in a school there are 2500 students and there are 13 teachers working, what will happen?
My instruction is that there are more than 35 teachers.
So that's why since from the report is not exhaustive, that's why I will direct the DI to apprise this code. Since the school is not represented, apprise this code. How many teachers are working in the school and what is the what is pupil teacher ratio? In terms of previous order, a report dated 29th August 2025 of the District Inspector of Schools AC Hooghly is placed before this court and same is taken on record. Stop. Next paragraph. On perusal of the report, it appears 500 students. From the report, it appears roll strength of the school is 1500 and 1500. But how many teachers are working in the school is not disclosed. Next paragraph. District Inspector of Schools AC Hooghly, being respondent number 3, is directed to file further report disclosing
how many teachers are working in the school at present, and what is working in the school at present, and pupil teacher ratio of the said school. Next one, let such report be filed by 7 days from date. Next paragraph, list the matter or by 10 days from date. Next paragraph, list the matter under the same heading for further consideration on 28 October 2025.
Subject teacher also, because
Subject teacher is not relevant. Court is proceeding on the premise that you are not a single teacher. But even if role strength does not, if people teacher ratio does not permit it,
then also provides is there.
yes.
They can approach not for filling up the vacancy.
Yes, take it back. Next matter.
Item number 10.
Yes.
Secondary board.
Well, the recommendation is a subject matter of challenge to the post of president at the instance of the MLA choosing the candidate. That has been mentioned, that is not in the law.
Who are you?
I am the head of the institution. Post of president, managing committee was dissolved by an order of the board. Lordship may kindly come to the order of the board at page 25. কার হয়ে আছে?
আমি কার হয়ে থাকবো? কার হয়ে কেউ নেই, তার হয়ে আমি থাকবো।
Lordship will get it at page 28. Being mindful of the aforementioned key finding, matter is disposed of with the recommendation.
দ্বিতীয় আছে
Yes.
Now, clause 2, Lordship will get it at page 28, running page. The present managing committee be dissolved and drawing and disbursing officer be appointed by the DI of schools. Drawing and disbursing officer, very next page, Lordship will get at 25th of February 2025, page 30. The drawing and disbursing officer has been engaged.
Yes.
Thereafter, the impugned notice, my lord, Lordship, is it legible copy to your Lordship? I don't know. I have made a supplementary affidavit. Like giving a better copy if it is not legible to your Lordship.
Page 33.
Page number 31.
31.
Yes, page 31.
Is it legible to your Lordship?
Give a better copy.
if we ask for a copy of this by letter, but we have not been.
No, I didn't write a letter, but understanding what they will supply as legible copy.
School education department তুমি লই যা তার কাছ থেকে তুমি চেয়ে নিতে পারবে
তুমি তোমার অনার্স ও নিউ তুমি কোর্টে আনবে।
Kindly look at this order. Report and opinion of the DI of schools for reconstitution of managing of the sponsored school by 26 schools named therein. Mala representation has been received from the concerned MLA for extension of the existing precedent.
emailটা কোথায়?
And managing committee of 26 schools.
26 school and my school is 11th one.
Yes.
My school is 11th one.
So this recommendation is not confined to your school.
it may be 100 schools, my lord, which is also confined to me, my lord. I am affected by this.
Yes.
Because the person who has been chosen is a tainted person according to us. And this MLA, my lord, is wanting to put someone.
Everybody now using tainted.
Tainted is now a blacklisted, I should say.
Now this recommendation is made on 24th of April 2025.
2025, my lord, this
President or PIE.
whether this recommendation is maintainable or not, my lord, will consider whether MLA can recommend it. MLA can, my lord, advise recommendation of a particular person because according to the school code, বইটা দিন একটু বলছি তো আমি তো দিয়ে দিচ্ছি আমি তার 423 পাতা বাদ কর ভুলে গেছি আমরা তো খেয়াল করিনি
merely recommendation by the local MLA warrants cancellation of this memo.
Of course, Bala,
Of course.
president who is
What are the other points?
the first point, my lord. First point I am taking your lordship. A president who is at least graduate from the recognized to be nominated by the Department of School Education, State Government.
Yes.
That has been done in this case. The Deputy Secretary has, my lord.
Deputy Secretary has nominated.
Yes.
What's wrong in it?
This is the reconstitution of the managing committee. Recommendation of the president has been made. Managing committee has not been reconstituted as yet.
Prior to that, it is made.
It is made by.
You will find that these nominations are made in midway because authorities do not know every day court is getting matters. That suppose yesterday I had to decide a matter. 2024 managing committee took charge. This managing committee, that managing committee will continue till 2027. Now recommendation is made in 2025.
Recommendation for president.
Nomination has been made in 2025 for presidentship.
Yeah,
Now, previous recommendation of 2022 was given effect to at the time of reconstitution.
Yes.
That president will continue up to 2027 if he is otherwise not disqualified. So therefore, the recommendation which was issued in 2025 at best can be given effect to after the new reconstitution is after when the new reconstitution would take place.
Reconstitution has not been done as yet. Election has not been conducted.
That is the usual system.
The recommendation
Because after election there will be less time to nominate. It's a time bound schedule. If there is no nomination by the department, so far president and PIE are concerned. In that event, a new managing committee cannot take charge. So what is the wrong in it, Mr. Bhattacharya?
First of all, intervention of the MLA cannot.
That is not confined to these schools. Therefore, 26 schools this has been done.
Also,
So all the recommendations will go.
Their views are taken their local representatives.
This
No, you not being swayed by the recommendation of the MLA.
It's not binding.
Recommendation of where is the illegality so far recommending the president of the school you demonstrate.
Power under
Rule 5 of the
semi-judicial sponsor has been exercised.
I can
That
understand
power is
if
there.
if the candidate is not graduate or if candidate is working in another school, perhaps he is not.
Master is so eager that he is present before your lordships.
And he wants to TDO to continue forever. That's his interest. Already in charge of the same managing committee.
Interesting
authority. And lordship
TDO to run.
So far as this particular person is concerned, he is
Independently not being swayed by the recommendation which is not confined to your school for 26 schools, you demonstrate that where is the illegality. Court is ready to consider your case.
My first of all, this
And the prejudice suffered by him. What is the prejudice he is suffering?
Person who is implicated in a criminal case.
Oh, that's this person who has been nominated.
Yes, who has been nominated. He's already implicated. I have stated in page 37.
Who is appearing for this nominated person? Mr. Asana. Actually, he must know those people, the client. So implicated in criminal case.
He is implicated in a criminal case.
Is there any parameteria provision like DCRB scheme 1981 that in case of initiation of criminal proceedings, a person will not get pension or gratuity?
only provisional. Is there any perimeter provision?
No, there
Because implicated in criminal proceeding does not mean he will be convicted.
That is, there are so many MPs. But still, he is not
then the parliament and the state assemblies,
and this case
all will go.
has been instituted by the headmaster himself.
No, it is, yes, that was the headmaster, complaint of the headmaster.
He is also
was that
implicated
taken
in criminal
copy.
proceeding.
Yes, that's as I understand unofficial. Page 53, Lordship will see in the criminal proceeding, my lord, he was implicated. That is there, my lord, in the court of the learned district and session judge, and that particular proceeding is still pending.
What are the charges?
Physical assault.
323 or now it has been changed.
ট্রান্সফার অর্ডারের সঙ্গে কি আছে এখানে? আশ্চর্য কথা। Well, he was in a criminal case, manner that is there. He was the assistant teacher of this school. He was a main member of the managing committee. He was the chairman of the municipality. Now he is the president. Yeah, he was the chairman of the
Now, if he was the assistant teacher of this school, now he is one headmaster of, of the same school. Now he has been transferred to another school.
Yes, he can.
So there is no bar.
No bar.
For law, Malad, so far as the qualification is concerned, Malad, we have nothing. But only thing, Malad, he is a.
If you want, I can relegate the matter to the Commissioner of School Education for comment.
You can let him decide. Let him.
Now, your lordship, I take it preliminary point I took it from the office.
Yes, yes.
The lordship can consider your lawsuit.
When your election is scheduled?
Lord, I tell your lordship,
When election is scheduled? Mr.
Immediately to be done. Immediately to be done. Headmaster is not doing it. It's for the headmaster to hold it.
He is stalling this. This is
He is
a device.
stalling everything.
No question of stalling. He was victimized. He was sought to be transferred on false allegations. This court intervened. Who is making false allegations? Kindly have a look to page 37. The learned friend, Mr. Bhattacharya's clients. Lordship, kindly have a look to the letter of the learned advocate of the petitioner, page 37. Just I am reading.
Yes.
Page 37, kindly have a look. This is the letter of the petitioner on his behalf, written by his learned advocate. Well, the page 37 is part of the letter under instructions so and so. Then 3. In the name of the nominated president, very many allegations are there. The said allegations are as follows. Criminal case number so and so, Pranab Bhattacharya versus Gopal Chandra Sahu. The respondent is still pending in the court of Chief Judicial Magistrate Tomluk. Then being instigated by the said Gopal Chandra Sahu, the previous president of the school managing committee illegally and falsely lodged a complaint with the police authority, a POCSO case against my client. So that is the petitioner. So what I want to show, there is a POCSO case against the petitioner himself, and he is complaining that many criminal cases are against the private respondent. And he is questioning the authority of the state government to nominate a person under Rule 5 of the Rules of Management of Sponsored Institutions 1972. The rule has to be challenged first. The outcome cannot be challenged.
What is your preliminary point?
No, actually, no. Can you come to page 25? This is third round of litigation by the headmaster. First round of litigation, this is the reasoned order. Page 25. This is of dated. Your losses will get the order.
January 2025.
21st January. Now, your losses, page 20. There are 3 parts of the order.
Transfer, appointment of DDO and
election.
Reconstitution.
Now, questioning the first part, he moved a writ petition. He has not declared, pleaded it.
Transfer order set aside. Partial, your lordship.
Transfer order. So you have recommendation of transfer and this. So you questioned out of 3-1.
Other way.
So my first submissions, you did not question the second two and third. You questioned the first one. Your lawsuits order, your lawsuits will find. The very first, 21st January order was questioned. The very second paragraph. Now your losses kindly come to page 33.
Just a minute, let me go. Yes.
Now your losses. So my submission kindly
So
consider.
transfer order goes.
Recommendation goes.
Now the DDO has been appointed.
Yes.
Now he is questioning the.
Nominated. Now page 33 your losses kindly have a look at this.
I am questioning that
Page 33.
person's identity as
Page 37.
that is the improved order. Steps have been
Kindly
taken.
see the date.
Just a minute, just a minute.
Page 33, 24,
April.
April 2025. Your losses kindly look at your lawsuits order.
Yes.
He knew about this. Now kindly look at the page 20 when he affirmed it. Lord, order 2, rule 2. You could have questioned the entirety. You have waived this. You have questioned your recommendation of transfer. When you are questioning before the court, this is on your face.
No, to November, my lord's order.
Oh no, the second order you have suppressed it.
My lord's order is 12 November.
25th June 2025.
The transfer
That was a.
When you filed that writ petition, Mr. Bhattacharya?
Earlier read.
No, the read WPA 12018 of 2025.
Well, this is affirmation date, if I'm not wrong. Yeah, affirmation is 21st May 2025. If I'm not wrong, but this was heard thereafter.
That was an internal communication. It was never sent to the school.
It appears to be sharp practice. Those are the recommendations which may go against you. Those are being tried to be frustrated. And the transfer order was challenged. At the time of challenging transfer order, you did not challenge the nomination.
I did not challenge the resolution of the managing committee.
This nomination order, which is challenged in the present report
Today,
that was issued in the month of April,
24th April.
of April 2025, and the writ petition was affirmed on 21st May 2025. No whisper about that nomination.
Document was not.
Now, first you got an order from this court whereby this transfer order was set aside. Since there was no formal initiation of disciplinary proceedings, and thereafter you have come with the present petition challenging this nomination.
He wants to be the monarch
And,
of this.
and it appears that there is ecstasy, it appears that there is no illegality in this with regard to the nomination.
Yes.
Nomination and also recommendation by local MLA. MLA can do this.
And it's not that the school has been singled out.
Yes.
It's not that the school has been singled out.
Connection with 26
Yes.
schools.
And Mala, this is constitutes the order includes the constitution. The frivolous litigation. It's a frivolous litigation.
It was not disclosed to us. I had no knowledge about the said document.
Lordship may have a look to page 33 once again.
Affidavit service filed on behalf of the petition was taken on record. Next paragraph. In the writ petition.
বলছে তো যার সাথে কথা বলবে should be dismissed with cause. The fancy litigation, frivolous litigation.
order dated 24th April 2025, issued by the Deputy Secretary to the Government of West Bengal School Education Department,
January 20.
is SL'd, whereby respondent number 9 was nominated as the president of the managing committee of Gopalganj Priyonath Bani Bhavan within bracket HS close bracket Paschim Medinipur. Herein after referred to a said school. Mr. Kamalesh Bhattacharya, learned counsel representing petitioner submits that the petitioner is the headmaster of the said school, who headmaster of school who questions validity of this validity of the order dated validity of the nomination order dated 24th April 2025. First, based on a document at pages 31 and 32 of the writ petition. Stop. By the said document dated 6 March 2025, issued by the Deputy Secretary to the Government of West Bengal, addressed to the District Inspector of Schools within bracket AC Purbo Medinipur.
So page 33 is not addressed to anybody, Bolo. Page 33 is not addressed to anybody.
31.
Yes, 31, yes.
Whereby report and opinion was sought for from the concerned District Inspector of Schools within bracket AC for reconstitution of the managing committee of 26 schools. Stop. Memo dated 6 March 2025 also depicts representation made by local MLA for extension of the existing precedent and person interested in educations of the managing committees of 26 schools in Purbo Medinipur. Stop. This person was the president of the erstwhile managing committee.
No.
So therefore it appears that the representation was not adhered to, because Mr. Bhattacharya, please come to page 31. It says representation has been received from the concerned MLA for extension of the existing precedent and PIEs of the managing committee of 26 schools.
Therefore, extension question does not arise.
So therefore, it appears that there was a representation by MLA for extension of this precedent. That has not been allowed. A new person has been inducted.
Extension of president of the instant person has been directed to be extended.
No, but this part, the respondent number 7 was not the president of this managing committee.
No.
Then-
That is not.
Then
Present managing committee it is now in
representation has
compliance
been
with the
received
recommendation
from
of
the concerned MLA for extension of the existing precedent and PIE of the managing committee of 26 schools, including your school.
That is page 30, your lordship.
So therefore, the erstwhile president was not he was not extended, or he was not nominated.
Or
A
his
new
tenure
person
was
has
not,
been
his
nominated.
tenure was not extended.
Yes.
Question of tenure does not arise because of dissolution of the managing committee.
That is a
Managing committee
Yes,
dissolved.
dissolved. But the previous president has not been recommended to be nominated as the president of the managing committee of the said school. হ্যাঁ কি বলছিলাম
But fact remains, my lord, this particular document did not reach us, my lord, prior to
জানুয়ারি কবে দেখাচ্ছি
according to the petitioner, said memo dated 6 March 2025, disclosing representation on behalf of local MLA, vitiates order dated 24th April 2025, whereby respondent number 7 was nominated as the president of the managing committee of the said school. Next paragraph, it is also submitted on behalf of the petitioner that a criminal case is pending against respondent number 7. Therefore, said respondent number 7 is not eligible to function as the president of the managing committee of the said school.
May another submission, my lord, kindly record that the letter dated 24th April
2025 was reached to the school on 1st of August 2025.
Yes.
Page 33.
না 26
The letter dated 24th April 2025 was
reached to the school on 26th of June 2025.
26 June 2025.
Therefore, we cannot, my lord, challenge.
24th April 2025, reached school on
26th June 2025 through the district inspector of schools.
On 25th of June.
26th.
Stop. Submission is also made that impugned order dated 24th April 2025 was received by the said school authority on 26 June 2025. Therefore, at the time of filing the writ petition being WPA 12018 of 2025, on 21st May 2025, petitioner did not have opportunity to question memo order dated 24th April 2025. Next paragraph. Mr. Subish Sharma, learned senior advocate representing respondent number 7. Submits process of reconstitution has been process of reconstitution of managing committee of the said school has been initiated by the concerned authorities in terms of the order of the president of the ad hoc committee of the West Bengal Board of Secondary Education dated 21st January 2025. So, it is also submitted that order of the president of the board, hereinafter referred to as board, order of the president of the board contains 3 separate directions. Stop. By first direction, petitioner was recommended to be transferred to another school. Stop. With a second direction, concerned district inspector of schools AC Purbo Medinipur being respondent number 6 was directed to take steps for
appointment of drawing and disbursing officer.
Regarding date, I should point out one thing. But kindly come.
Just a minute, I will hear it. Otherwise, I will lose my momentum.
I know. Normally, I do not do that, your loss.
হ্যাঁ কি বলছিলাম বাই সেন্টেন্সটা একবার বাই দ্য সেকেন্ড was directed to take steps for appointment of drawing and disbursing officer within bracket DDO in the said school upon dissolving the existing managing committee. Stop. Stop. In terms of third direction, response number 6 was also directed to initiate the process of reconstitution of the managing committee in accordance with law. Stop. Next paragraph. It is further submitted on behalf of respondent number 7 and the state respondents that as per direction of the president of the board, as per first direction of the president of the board as contained in order dated 21st January 2025, petitioner was recommended for transfer, which was questioned by filing a writ petition being WPA 12018 of 2025 before this court. Now, 2025. Stop. The writ petition was disposed of video order dated 25th June 2025 by this court. Setting aside a recommendation for transfer of the petitioner dated 21st January 2025. Stop. According to the respondents, since the writ petition being WPA 12018 of 2025 was instituted on 21st May 2025, impugned order of nomination dated 24th April 2025 was according to was already issued at the time of instituting said writ petition, but same was not questioned. Stop. Petitioner found it fit to confine the issue against a recommendation for transfer dated 21st January 2025. Stop. After recommendation for transfer of the petitioner was set aside by this court, video order dated 25th June 2025, by filing this writ petition, challenge is thrown to the order of nomination dated 24th April 2025 in order to frustrate process of reconstitution. Next paragraph. Mr. Dotto, learned senior advocate representing the state respondents, has drawn attention of this court to a letter dated 3rd June 2025, which is at page 37 and pages 37 and 38 of the writ petition, where from it appears that a case under POCSO Act is also pending before the petitioner. Before the petitioner.
There
Is
is no
pending
case pending, well, let him show.
against the petitioner.
It is only
It
an
is his
allegation.
letter. I am relying on his letter.
Just recording his submission.
Yes.
Unnecessarily you are implicating.
I am just recording his submission.
That is your letter.
Yes, Mr.
Not my
Shanlal.
document.
Mr. Shanlal, what you wanted to submit?
Now your losses can have a look at the page 33.
Yes.
Well, this is a memo number 952 dated 24th April 2025. Bottom column number 10. This was forwarded to the school. Then your losses kindly come to the next page.
No, I couldn't follow. Page 33.
33 is memo number 952 dated 24th April 2025.
Where?
Page 30. Page 33.
To left hand side, memo number 952.
Yes, 952. Yes.
The right hand side date 24th April.
Bottom is
952.
Right hand side, exactly.
Dated 10th March 2015.
No, 24th April 2025. Page 33. Date of the memo.
Yes, 24th April 2025.
Now kindly, my lord, consider copy forwarded to serial number 10, school. Your losses, you will not find any abatements. I will show what abatement he has made. Now your losses, kindly have a look at page 34.
Where is the school? Serial number?
My lord, 10. 9. President of the West Bengal School of Higher Secondary.
Without wasting at after 115, page 49, the DI has forwarded it. This particular memo on
All right.
26 June, page 49
Yes,
is the
I will do that. I will do that. My lord, page 34. Memo from District Inspector of School dated 26th May. My lord, kindly have a look. Address to the head of the institution, list enclosed. I will go to the list subsequently. My lord, subject verification of educational qualification eligibility criteria of the president and PIE. As your lordships, then kindly see the next page of the list. Serial number 12. My lord, Gopalganj, my lord, school. Gopal Chandra Sahu, the president. So, my lord, first, my lord, on 25th April memo, he doesn't say whether he received or not. Second, this was additional to that on 26th
May, after month,
2025.
It was after instituting the writ petition on 21st May 2025.
Yes. My lord, that's your losses, the affirmation date. When he filed, I do not know. Subsequently. And then your losses, my lord, the order date. The
24th of April 2025.
No, that's the other order date, second order date of
25th June 2025.
Exactly. And then your losses kind of look at this, what he says. So he knew about it before your lordship's order was passed on the writ petition 5, paragraph 12 and 13.
Yes, that is true that on the date the writ petition was disposed of, that was 25th June 2025.
Exactly.
Then, as per the submission made on behalf of the petitioner, he received this memo.
Now your lordship,
come to page 49.
I will do the
official communication by the DI of school in the
page 34 is the official communication also.
Page 49 is the only document that has been forwarded to us. Page 49. Can you look for once? Page 49.
Very well.
26th of June, the DI is forwarding.
Yeah, forward করে না direct forward করা আছে
Well, I also submitted.
Court is required to consider the validity of this order of nomination dated 24th April 2025. Stop. Only point which has been agitated on behalf of the only point which is agitated on behalf of the petitioner is memo dated 6th March 2025 of the Deputy Secretary to the Government of West Bengal, addressed to respondent number 6. wherein representation of local MLA was referred to, that was for extension of extension of existing precedent and persons interested in education of the managing committees of 26 schools under the jurisdiction of respondent number 6. So, if court proceeds on the premise that local MLA made a representation for continuation of persons who were functioning as president and persons interested in education in those 26 schools, that ought not vitiate the process of nomination as made with the order dated 24th April 2025 by the Deputy Secretary to the Government of West Bengal. Stop. In the presence, in the said school, managing committee was dissolved in terms of the order dated 21st January 2025 of the president of the president of the board, and DDO has already been appointed with a memo dated 25th February 2025 by the respondent number 6. Stop. Therefore, question of continuation of erstwhile president of the managing committee of the said school does not arise. Moreover, respondent number 7 never functioned as president of the managing committee, never functioned as the president of the managing committee of the said school. Stop. In consideration of aforesaid facts, it can be inferred that
should be 9. Respond number 9.
9.
By name
পেমেন্টটা 9 করে দেবে সব জায়গায়। কি বলছিলাম? Inferred that representation made by the local MLA was not accepted so far present school is concerned by the deputies, or was not considered so far present school is concerned, was not কি বললাম? Was not considered so far present school is concerned by the Deputy Secretary to the Government of West Bengal, while nominating respondent number 9 as the president of the managing committee. Stop. Next paragraph. Moreover, the said school should not, moreover, said school ought not to be permitted to run in presence of DDO for an indefinite period. And there is requirement to reconstitute managing committee immediately for the academic interest of the said school. Stop. It appears that after recommendation for transfer of the petitioner dated 21st January 2025 was set aside by this court, the order dated 25th June 2025. By filing this present writ petition, an attempt is made to frustrate the reconstitution process. Stop. Next paragraph. it is not, it is also not demonstrated before this court that how respondent number 9, it is also not demonstrated before this court that whether respondent number 9 is ineligible to function as president of the managing committee of the school, apart from a feeble attempt made on the part of the petitioner to rely upon the memo dated 6 March 2025 in order to invite attention of this court that there was a recommendation by the local MLA. Next paragraph. In view of aforesaid consideration, this court does not find any infirmity in the order dated 24th April 2025, where respondent number 9 has been nominated as the president of the managing committee. Stop. Next paragraph. Hence, the writ petition stands dismissed. Urgent xerox certificate.
Although the affidavits have not been called for, allegations are deemed to be denied. Allegations. কিছু তো বলতে হবে, খিদে পেয়ে গেছে এখন।
Item number 11.
Yes.
ওইখানে রাখিস না মিশে যাবে এটা কালকে ফাইল না নট টুডে ফাইল ওর উপরে রাখ স্পেশালি ফিক্স করতে নেই কোন ফাইলটা উঠবে করে দিয়েছি
Lordship, I am appearing for the state. I have received the latest information. The petitioner neither prayed for released order in the earlier school and she has attended all along. Only in the month of January and February, three earned leave. She obtained no medical leave. No medical leave.
What happened by the petitioner made a prayer for extension of it is not on here. But on 5th of November 2020, 5th of November 2024, petitioner was undergone a surgery. I have the document. In the year named, petitioner was an old. In the both year named, petitioner was undergone a
How she attended this?
November, from 3rd November 2024 to 5th December 2024, petitioner was absent in that particular prior.
January and February.
No, you tell me that because once a recommendation is made, which was made on 23rd of October, what prevented you to join in the month of January and February?
Yes, but petitioner made a prayer on 20.
Because your prayer, date of prayer for extension of validity is 20th February 2025. At that point of time, you are not in ill, and you were attending the school where you are working regularly. Yes, for which how long you obtain leave?
On 3rd November 2024 to 5th December 2024.
And what is the date of recommendation?
Recommendation subsequently
23rd November 2024. 23rd November 2024. And you remained absent up to 6th December 2024. So thereafter, you had an ample opportunity to join the post.
My application, I made an application for extension, but that has not considered. It is the case within 90 days I made in on medical ground.
File your affidavits. In terms of order dated 28 August 2025.
Consideration order, they are rejecting order.
A report is filed by the district inspector. A report is prepared by the district inspector of schools AC Birbhum dated 25th July 2025.
Statement. January, February,
which is taken on record. Stop. Next paragraph, from the said report dated 25th July 2025, it appears as per record of the school where petitioner was working,
She did not take any medical leave. Top petitioner availed 3 days casual leave in the month of January 2025 and February 2025. But during this period, no medical leave was availed. Whereas in data dated 20 February 2025, which was addressed to the Secretary of the Secretary of the West Bengal Central School Service Commission, prayer was made for extension of validity of recommendation dated 23rd November 2024. Since petitioner was unwell. Stop. Statements made by the petitioner in the letter dated 20 February 2025 is not corroborated from the report dated 25th July 2025 of the concerned District Institute of Schools AC Birbhum. Stop. Next paragraph. Issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this petition be filed by 2 weeks after ensuing pujafication. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next. Party shall be at liberty to mention the matter before the bench, before the appropriate bench, for expeditious hearing after the time fixed for exchanging. Next matter.
Item number 12.
এটা তো কথাই হয়ে গেল। Why headmaster did not receive the notice of the advocate when the department was directed to issue administrative notice? It must have been. Let me see the report of the department.
Grievance is against the. I'm sorry.
Yes.
The grievance is that for the purpose of running the institution, the head of the institution, Millard, is not adhering to the provisions of Rule 28C of the Management of Recognized Non-Government Institution 1969. Now, Millard, there are various allegations, including financial dereliction, financial irregularities, dereliction of duty, abuse of the office authority, then Millard not taking into, not Millard doing the proper action for Millard, the compliance of the midday meal rules of 2015. Now, for that, Millard, an objection was filed. Now, objection was filed before the District Inspector of School, Secondary Education.
Who are you?
Millard, we are the teaching and non-teaching staff of the school, all. Milord, this headmaster, Milord, I have again another case.
Any representation?
Yes. That is at page 31 to 38.
Whether the board is party?
No,
Board is party.
West Bengal board.
no, my lord.
Why you have not added board as party?
They are the answering response issued.
Milord,
Against the headmaster?
Oh. So now the decision becomes.
Milord, I say, Milord,
No action has been taken, but the disciplinary process has been taken. Suspension letter has been.
Milord, I have the only the instructions. I have only the instructions.
My lord was pleased to
Page
direct me
39.
to take instruction. I have taken instruction.
This grievance, Milord, let it
Just a
be.
minute.
I'm sorry. Milord,
Please wait. Whether it is not disclosed in this report dated 2nd September 2025, whether proceeding has been initiated or not.
Yes, that's my, that is the
Board.
thing, Milord, I wanted to
Lord.
indicate to my lords. It only says that I have been, this person, this headmaster has been.
But you have not made board as party.
No, board is not made a
You
party.
have not made board as party. And your teachers who are working in the school, they are habitual absentee.
No.
Then why they do not know that the teacher headmaster is under suspension?
No.
That's why he could not receive the notice.
Order is already annexed.
We have annexed this order. Why? Because this order at page 39, kindly see, I have annexed this order at page 39 of the writ petition.
You are representing the headmaster, whether you have been suspended headmaster, whether any communication regarding initiation of proceeding or
Nothing. Suspension. The suspension is.
nothing else.
Nothing else.
What is the prayer in the initiation of the disciplinary process?
So I have,
Initiated disciplinary process.
so far as my prayer
Suspension
is,
is not initiation of
Charge sheet is the initiation, but the.
I prayed for investigation into the allegations made by the teaching and non-teaching staff. Thereafter, what the authorities will, they will decide, they will do.
बोर्ड के पार्टी করলেই তো बोर्ड বলে
issue. In terms of order dated 25th August 2025, administrative notice was served upon the president of the managing committee, was served upon this one number 8.
Seven and eight.
Stop.
No, your lordship directed
Order dated so and so. As it appears from the report dated 10th September 2025 of the assistant registered Roman 8, and same is taken on. Next paragraph. A report is also filed by the District Inspector of Schools AC Hooghly dated 2nd September 2025. A report dated 2nd September 2025 is prepared by the District Inspector of Schools AC Hooghly, and same is filed by the learned advocate representing the state respondents. Comma, a report is taken on. On perusal of the report, it appears that headmaster of Panchghara High School, Hooghly, has already been placed under suspension. With a order dated 17 June 2025 issued by the President of the West Bengal Board of Secondary Education. Stop. On perusal of suspension order dated 17 June 2025, it further appears that concerned authority of board considered preliminary inquiry report furnished by the District Inspector of Schools AC Hooghly and found considerable substance in the allegations made against the headmaster of the said school. ওই সেট স্কুল করে দেবে উপর সেট স্কুল। President of the board made it clear while issuing suspension order that headmaster of the said school was suspended in contemplation of disciplinary proceeding. Next paragraph. In the present writ petition, teaching and non-teaching staff of the said school have voiced grievance against the conduct of the headmaster. Stop. Prayer was made for taking steps against the said headmaster on holding inquiry. Stop. Though board has not been arrayed as party, but on perusal of the suspension order dated 17 June 2025, it appears that steps have been taken by the concerned authority of board for initiation of disciplinary proceedings, and the headmaster has already been suspended. Stop. Next paragraph. Keeping in consideration of the steps taken by the board, no further order need be passed at this stage. Stop. Writ petition stands disposed of.
Only one thing, kindly see my prayer age. My prayer age.
Please.
I said that you have to get into the allegation made by.
You have not made board as party.
So I
What
said, "Milord,
investigation?
I have made it before the DI.
Defective writ petition suffers from defect of parties. Next matter.
I'm deeply obliged.
Item number 13.
Chief indicated that only notice was issued upon the headmaster, but I find that the president and the headmaster, your lordships passed
Yes.
out. Your lordships passed the order
Yes.
that both the particular headmaster and the particular milord, the president, they should be informed. Your lordship indicated that the head.
No, I have recorded that today the desk number 8 has received notice.
But I find
Headmaster did not receive notice because he is suspended. How he can receive notice if you send the notice to the address of the school? He is not coming to the school on since suspension. So that's why the department has also furnished the report that president of the managing committee has received notice on behalf of headmaster.
Hello. Grievance, sir. দেখেছি তো
Yes, report. Why undertaking was required? Because of calculation of and this was given on
28 28 এই যে ওইটা বের না হ্যাঁ আট নয় নয় নয়টা করা নেই 8-এর পর 9 লাস্ট
পুলিশ বলতো
এই যে লাস্ট পেজ
লাস্ট পেজ
9টা লাস্ট পেজ
just a minute.
লাস্ট পেজ ক্যালকুলেট এইটা লাস্ট পেজ হ্যাঁ এই লাস্ট পেজ 11 ওইগুলো তো তুমি করতে বারণ করেছো এখান থেকে করেছি হ্যাঁ হ্যাঁ 2
तीन चार पाँच छः सात आठ नয় লাস্ট নয় ওইগুলো বাদ দিয়ে তো করেছি এই তো নয় 11 ধরে হচ্ছে 9 হয়েছে
So subject to furnishing undertaking, 3% additional increment was granted. Now, while processing your pension case, difficulty arose.
No, the commissioner has sought for the undertaking which was furnished earlier by the petitioner. That was
In terms of this
order 30th
30th October 2024 order. So you have furnished
Yes,
undertaking
my lord.
before whom?
Before the DI.
Where is the order of the commissioner, order of the authority while processing your pension case?
My lord. Order the last. But the one order has been communicated dated 13th August 2024.
No, 3% additional increment has been granted to you.
Yes, my lord. But
What you are praying for?
But the financial benefit, that is the area salary and area pensionary benefit, has not been granted. Area salary has to be
When you have retired?
But
রিটায়ার করেছে কবে এখানেই পেয়ে যাবো রিটায়ার্ড ফ্রম সার্ভিস 31/1/2021 রিটায়ার করে যায়
31st of January 2024.
yes, ma'am. With effect on
31st January 2021. So now you are praying for area
salary?
area salary.
এছাড়া ডিউ আছে
না না দুটো পেয়ে আছে
So whether your area benefits have been considered by the authority?
Yes, my lord. 3% already granted by the
No, 3% granted in terms of this order.
Yes, my lord.
Now thereafter,
পেয়ার সি দেখো পেয়ার সি এরিয়ার স্যালারি চেয়েছে পেয়ার এতে চেয়েছে এরিয়ার স্যালারি
now who has demanded this furnishing of undertaking was
But the pension, provident fund and group insurance
recorded in the order dated 30th October 2024 by the additional secretary. Now thereafter you are receiving pension.
Yes,
pension, but the area benefits you are saying you are praying you are seeking area retirement dues as well as area salary. Now that is to be considered by the authority.
Yes, madam. But the earlier
is fine with the DPP.
But the pension, the matter is to be decided by the DPP. But so far as the area salary, it is to be considered by the DI, subject to my lord's kind consent.
So pension is to be as well as because DI is the pension sanctioning authority. So therefore, areas of pension and areas of salary both are to be decided by the DI.
By the DI.
Have you made any representation?
Yes, several representation. But the page 107, my lord, last representation.
কাকে দিয়েছে
Page 100 onwards are my representations.
বাই পোস্টে দিয়েছে না
Now, if undertaking is forwarded, then this area benefits can be released by the Director of Pension Provident Fund.
Everything, since the
No, last occasion, this court passed an order, the agenda matter so that you can forward the undertaking to the DPPGP.
Yes.
So have you forwarded it?
Yes. Kindly have a look at the
last page report
Is the report?
সাতাশ তারিখে ইয়ে করেছে, 28 তারিখে দিয়ে দিয়েছে লাস্ট ডান দিকে রাইট সাইড।
Thank you.
সমস্ত পেপার ডিবিপিজির কাছে আছে, সার্ভিস বুক থেকে আরম্ভ করে সব।
But where it is mentioned that the undertaking is forwarded, that is the main issue.
ও সেটা হচ্ছে, সেটা ইয়ে তোমার
There is no mentioning of undertaking
3-4
which was furnished before the DI in terms of the order of the Assistant Secretary School Education Department. See, since it is admitted that undertaking was submitted before the District Institute of Schools, it is required to be forwarded to the Director of Pension for processing his claim relating to arrear benefits.
This is not specifically indicated.
Yes.
But my lord, if you are so kind, in connection with the subject cited of the pension case.
I have read the entire memo, then I am asking you, where is the mentioning?
এখানে মেনশন করেছে, এখানে এই ও
issue.
Your lordship is absolutely correct. But
That is the crux of the issue.
but all papers have been submitted to the
In terms of the order dated 28 August 2025, a report dated 8 September 2025 of the District Institute of Schools AC Nodia is placed before this court and same is taken on record. Next paragraph. Mr. Acharya, learned advocate representing the state respondents, in reference to a memo dated 27th August 2025 has submitted that relevant documents along with calculation sheet, input sheet, service book, pension booklet and other service book and pension booklet were forwarded to the Assistant Director, Pension, Provident Fund and Group Insurance for processing claim of the petitioner. According to the state respondents, now the Directorate of Pension, Provident Fund and Group Insurance, based on relevant documents, needs to take decision on the claim of the petitioner seeking release of arrear pension. Release of arrear pension as 3% additional incremental benefits were allowed to the petitioner by the Additional Secretary, School Education Department, vide order dated 30 October 2024. Stop. Next paragraph. Question arises whether vide memo dated 27th August 2025, District Inspector of Schools AC Nodia has forwarded the undertaking which petitioner furnished in terms of the order dated 30 October 2024 of the Additional Secretary, School Education Department, or not, School Education Department, or not. Next paragraph. On perusal of memo dated 27th August 2025, it is not clear whether undertaking furnished by the petitioner before the District Inspector of Schools was forwarded to the Directorate of Pension, Provident Fund and Group Insurance
Stop. If undertaking has not been, if aforesaid undertaking is not forwarded till date, District Inspector of Schools, AC Nodia, being respondent number
But 4 months.
4 is directed to forward the same by 7 days from the date of communication of this order. Stop. Next paragraph, on receipt of undertaking and other relevant documents which Directorate of Pension, Provident Fund and Group Insurance has already received, with a memo dated 27th August 2025, comma, Director of Pension, Provident Fund and Group Insurance, being respondent number 7, shall pass necessary order for release of arrear pension within a period of 4 weeks from the within a period of 4 weeks thereafter. Stop. Decision to be taken by the respondent number 7 shall be communicated to the petitioner by 10 days thereafter. Next paragraph. Petitioner, learned advocate representing the petitioner has also submitted that in view of granting 3% additional incremental benefits, petitioner is also entitled to receive arrear salary. Stop. Leave is granted to the petitioner to make a representation to the district inspector, to make a representation to the respondent number 7, respondent number
subdivision
4 by fortnight from date. Stop. If such representation is made, respondent number 4 shall decide the same in accordance with law within a period of 6 weeks thereafter. Stop.
5 months. ADI subdivision.
No, DI is party. No, DI, no, DI. DI will take decision. I have directed 6 weeks. Writ petition stands disposed of urgent xerox certificate. All the fixed matter.
TPA fixed matter item number 2182239.
Shiva felt against it.
Yes.
As far as the rule and advertisement part is concerned, I have made my submissions. On the last day, I was placing one order passed by the coordinate bench dated 1st October 2019. Dealing with this selection process, dealing with the issue of
one question also cropped up that relaxation relating to B.Ed was withdrawn on 31st March 2019.
31st March 2019.
Whether the candidates who obtain B.Ed qualification prior to relaxation of
prior to said relaxation which was granted, or prior to withdrawal of such relaxation, would be considered or not?
Yes, that is what I'm submitting. That is what I pointed out from the rules. Rules does.
Because you submitted that the last date is sometime in October 2016.
Yes.
24th October 2016.
Yes, yes.
Now, even those candidates who were not possessing B.Ed qualification, they were permitted to apply.
Yes.
They were permitted to apply because of the relaxation.
Yes.
Because of the relaxation
Yes.
which was operating in the at the material point of time. Now that relaxation was withdrawn on 31st March 2019.
Yes.
So question crops up whether that prior to withdrawal of relaxation, whether the candidates who obtain qualification would be permitted.
That is the basic question. In reply to that question, I have pointed out from the rules that the rules did not give any relaxation. The schedule showing the minimum eligibility criteria, all the combination subjects or requirements given for the candidates, each one included training qualification, that is the B.Ed or DLEd. So there was no relaxation in the rule, but because of the NCT relaxation which was continuing, in our advertisement, we had mentioned that yes, untrained candidates.
If there is no relaxation in the rule, then why you did not stick to your rules? And why you permitted the candidates who did not have yet qualification at the material point of time, or within 24th October 2016, why they were permitted to apply? Because that created confusion in the mind of the candidates who were not having B.Ed qualification on or before 24th October 2019, 24th October 2016.
Now, most of the decisions which were taken by the commission came from the education department in the form of directions, letters, whatever. So we carried out what came to us from the education department. What the education department had, what was coming from the central government. So relaxation was allowed. So we allowed them to participate. When we allowed them to,
how this permission was granted, because rule is silent with regard to relaxation.
Yes.
Your advertisement is silent with regard to relaxation. Then how it was permitted?
Advertisement is not silent.
There was
advertisement is very clear that even the untrained candidate can apply because of the relaxation. So the advertisement allowed them to enter into the process. At that point of time, possibly it was not possible to visualize that the relaxation will be withdrawn midway. So they were allowed to continue. 2019.
So now the next question, which you would be confronted, that if there is an indication in the recruitment notification that even untrained candidates, because you draw my attention to a note,
yes,
of a relevant part of the recruitment notification. Now, if there is a relaxation in the recruitment notification, then ultimately why subsequently you took this particular stand that they are not entitled to be considered?
That is the present point which I am arguing is that first there was my rule followed by the advertisement. Then the question,
cannot rely upon this rule in view of the relaxation granted in the recruitment notification.
Yes, yes. So naturally the question arose, which fell from the court also, that changing the rules of the game midway of the selection process. In response to that, I had submitted that various litigations, orders of court also tied my hands, bound us to follow certain procedures, which include this trained, untrained issue also. The order which I was showing on the last day, that is 1st October 2019, passed by the coordinate bench, it was while hearing the question of trained, untrained with regard to this selection process. It is that bunch of cases which ultimately Justice Bhattacharya, Moushumi Bhattacharya, set aside the entire selection process, directing us to start from 12 stage onwards. So in the middle of the litigation, the court first wanted an assurance that we have excluded all untrained candidates because there was no longer any relaxation in their favor. So we had to come up with that. We filed the written instruction in court, which was taken on record, recording that we are proceeding only with trained candidates because in those writ petitions, the allegation was that we have included them.
Untrained.
Untrained. The trained had filed the petition saying that we are including the trained, untrained candidates. That is what I was showing from the order which I had handed up 1st October 2019.
Where court will find it? We have supplied separately.
Yes, yes. Last day also, my lord was looking at it. 1st October 2019.
Yes, 1st October 2019.
Page 2, can you see?
This is the final order.
No, this is in the midst of the litigation, this question came up and we had to give the assurance before we were allowed to proceed with other issues.
Just a minute. Yes, yes, place it.
Yes, kindly come to page 2. Towards the middle, I'm reading the second last line of the first paragraph. The allegations enumerated include that. So what were the allegations in the writ petition? Serial number 2, untrained candidates were called for personality tests. This was the allegation. Now kindly just come to page 3. The second paragraph from the bottom. The court records that the said order also records the instruction issued by the commission that no trained candidates have been called for personality tests.
No untrained candidates?
Yes, untrained candidates were called for personality test. So this is recorded in an order prior to 1st of October. That is 1st July, that is mentioned there.
Yes.
Finally, the court records at page 6. The last paragraph at the bottom, page 6. On the returnable date, the commission handed up written instructions with the information that a total of 44194 candidates have been verified under Rule 12(3). That all untrained candidates have been excluded from the interview list. 586 candidates have been brought into the zone of consideration on the basis of information which provide. That is not very relevant for us. So this written undertaking, written instruction, it has been filed in court, taken on record.
Yes.
So the court also was insisting, though we were already excluding them due to the withdrawal of the relaxation, court was also insisting that yes, you have to do it. And through various orders, it is clear that how we have given the court assurance that we are removing the untrained candidates. Now, the final order which was passed by Justice Bhattacharya in this matter, that I have annexed to my affidavit in opposition. Here also, 6 points were urged before the court. The 4th point dealt with trained and untrained, and the court has dealt with each point separately. If my lord would kindly come to page 17, where the judgment starts. And page 44,
11 December 2020 judgment.
yes, yes.
Yes.
Page 44 of the affidavit, page 28 of the judgment. At the bottom, my lord will find contention number 4. Untrained candidates were brought within the zone of consideration in violation of the third proviso of Rule 4.1. Rule 4.1 stated that you are to have all the qualifications at the time of making your online applications, and that is to be indicated in the application form. So what the petitioners say, the court has given the petitioner's argument, our response, and then the court's finding. It's not very long, so I'm placing it. According to counsel, the commission's report of 27 September 2019 states that almost 600 candidates were brought within the zone of consideration on the basis of information which was not provided in their respective application forms, meaning that part was blank. The petitioners contend that the candidate's training qualification should have been mentioned in the online application forms and could not be enhanced subsequently. These are candidates who actually had B.Ed qualification
But they did
prior
disclose
to,
it.
yes, but they could not upload it.
Some of the matters separately came before this court.
Yes, we wanted to include them because we visualized that, yes, it can happen that while making online applications, due to technical glitches, due to server problems, many candidates from remote villages, they might have difficulty in filling the form, and maybe one parameter gets left out. So in verification, if we find that, yes, you have a degree prior to 2016, then we were including. That was also objected to. Answer of the commission. The answer of the commission is that several candidates had acquired their B.Ed degrees before the last date of submission of the application forms, and hence the commission treated these candidates as B.Ed qualified. Not candidates who got it within 2019. They are candidates who had it
Prior to 24th of October 20.
Yes.
But they did not disclose those.
Yes.
B.Ed
So nobody could have any real reason for not disclosing a degree which will qualify me for participating in the selection process. It is also urged that the third proviso to Rule 4.1 is directory in nature, since it does not provide for any consequences in case of default of the said rule.
So therefore, the commission made submission in support of the untrained candidates.
Yes, for them, those who had it prior to it. That according to the commission or any recruiting body, that is the purpose of verification, to see whether the candidates have the qualifications, did not have the qualifications, whatever, checking of the credentials. Online applications do not come with any documents, only the application comes. The documents are checked later. Now, rules violated. Rule 4.1, third proviso. Provided that certificates received on or before the last date of application and mentioned in the application form, this became the obstacle. Since they were not mentioned in the form, though the rules required it. So our allowing them, that the court did not entertain.
Because it appears that in terms of third proviso to Rule 4.1, it is not permissible.
Yes. So the court, now the finding. This is all with regard to the B.Ed, training, untrained. The significance of a cutoff date in responding to an advertisement for recruitment was considered in Alka Oja and Rajesh Kumar Sharma, where the former decision, the Supreme Court relying on so-and-so, held that in the absence of a cutoff date, the eligibility criteria shall be applied with reference to the last date appointed by which the applications have to be received by the competent authority. Rakesh Kumar Sharma reinforced the position that a person on his eligibility as on the last date of submission of his application form has a right to be considered against the particular vacancy provided. In the present case, the third proviso to Rule 4.1 of the rules of the 2016 rules stipulates that certificates received on or before the last date of application shall be counted for academic and professional qualification. Clause 3 of the recruitment notification advertisement for the post in question dated 23rd September 2016 provides, after submission of online application form, no further rectification will be allowed. So this also went against the candidates who already had the degrees. Firstly, you have to mention it in your online application. If you have not, you cannot subsequently rectify it. Even if the contention of the commission that certain candidates were allowed to add their qualifications, since the qualification had already been obtained by the candidate before the last date of submission of the application form, is accepted as correct, it is undeniable that the cutoff date was relaxed for several of the candidates to the exclusion of others. It is equally correct that apart from several candidates being treated as B.Ed qualified, the marks under the other heads, namely TET weightage, was modified after the last date of submission of the application forms. The answer of the Commission that the third proviso to Rule 4.1 is directory and procedural in nature, or that no candidate had suffered infraction of his right, is not acceptable. The rules prescribed cannot be complied on a selective basis. Either the compliance has to be uniform, or alternatively, selective relaxation of the rules must be upon notice to the candidates who will be affected by such change to the rules.
This is the relevant part.
Yes. So this is what was the finding. So in short, the court did not allow non-B.Ed candidates to participate, even to the extent of candidates who already had the degrees but did not mention it in their online applications. These candidates, the 2019 candidates, or even after that, we have never supported them. But these candidates who had the qualifications, due to some problem, maybe they could not upload it. Those candidates we wanted to include, but the court...
To some omission.
Yes, but the court...
The court did not allow.
No, because the rules did not allow, so naturally the court did not allow us to include them. Even relying upon the advertisement, where it is stated that subsequent change of the cannot be allowed. So after submission of the online application, no further rectification will be allowed. So this
will be done, that will be based on what was the position relating to candidates vis-a-vis their qualifications till 24th of October 2016.
Yes, provided they have mentioned it in their online application. So the court was also
disclosed in their online application.
Yes. So the court was also binding us. It is not a question where I could think independently. So I had a rule without a relaxation. I gave a relaxation in my advertisement because of the NCT regulation, which was relaxation rather, which was given to the commission, on the basis of which we allowed them to participate, but the court did not allow it. That is the biggest hurdle which
Yes. So therefore, the situation as you are submitting is based on the observations and made by the coordinate bench in those two orders.
Yes.
So according to these observations which are made by the coordinate bench, close this window.
Yes, yes.
Close this window. It is not no more left open.
Yes, that is basically.
But at the same time, say, court is considering on last occasion that when this advertisement was published in 2016, a relaxation was considered was there in terms of the notification of MHRD or NCT.
Yes, yes,
NCT. A relaxation was granted. That relaxation relating to obtainment of B.Ed qualification was withdrawn in 2019.
Yes.
Now, why the candidates who obtained this qualification prior to withdrawal of relaxation will not be considered in the event vacancies are available?
Firstly, I will argue this point later properly, but firstly, that particular notification or whatever circular, it according to me does not apply to para teachers. It applies to teachers who are working in a substantive post. Secondly, that circular does not apply to a selection process. It was introduced to protect in-service teachers from losing their jobs. It is now compulsory to hold the training qualification. Those who are in service without training qualification, they were given 2 years' time.
Where is that relaxation order? Do you have whether it is on record?
No, the one which my learned friend handed up, that was not part of the records.
Then it was extended from time. Act is section 23, the right of children free and compulsory education at 2000. Actually, when this was passed,
Yes.
I was.
This is the last relax.
This first, see this first. That is how it has been.
তোরা যেটা হ্যান্ড অফ করেছিলি আগে।
Sir, you can provide to section. Can I read this section of the provide?
No, this is the relaxation order, Mr.
Order.
Bhattacharya is
I am
giving.
saying of section,
Right to Education Act.
No, can you speak this one?
এই রাইট টু এডুকেশন একটা আনিয়েছিলেন না, দেখো তো এটা নিচে আছে মনে হয়। দেখি দাও আমায় বার করে দিচ্ছি।
This
2009 Act.
2000?
Yes, yes.
9 Act.
Yes.
But in provision. In first April 2003.
Yes, yes. Which section you are relying on?
Section 23 subsection 2 second subsection 2 second clause. So what has happened that what happened? I'm just telling you this scenario because I was in the parliament that time. In all over India, that maximum untrained teachers have taken down. The NCT guidance for the teachers together. That time the selection first was second provided for every teacher appointed.
This is proviso to say to section 23(2), subsection.
Second proviso.
Yes, yes, yes.
Provided further, every teacher appointed or in position as on the 31st March 2015 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years on the date of commencement of the Right of Children and Education and Compulsory Education Amendment Act of 2006. This is the provision has come. And you see, let us read section 23 full. Any appointment, but first, any appointment qualifications as minimum qualifications as laid down by an academic authority or by the state government shall be eligible for appointment as a teacher. But a state does not have adequate institutions. Offer that was a real
Consideration.
That time was a real difficulty was the education center was very less. West Bengal also it was less. Given the chart, I can't remember now. Then the all this
These training institutes were
training
less.
institutes were increased. That time it was there. And West Bengal was having a much limited disadvantage. And trained teachers were not available. Percentage-wise, trained teachers were not available.
Post Tulsi Boxi case.
Yes. That trained teachers were less. Untrained teachers were given more. That was many litigations were there also. And then where state does not have adequate institutions offering courses of training in teacher education or teachers policy minimum quality as laid down under subsection 1 are not available in sufficient number, the central government may, if it is deemed necessary by notification, relax the minimum qualification required for appointment as a teacher for particular not exceeding 5 years as may be specified in that notification. That is the original act when was there. Then provided that a teacher who at the commencement of this act does not possess minimum as written under subsection 1 shall acquire such minimum qualification within a period of 5 years. That is when the act was there. In the that the act is here is 2009, right? The 5 years has to be obtained. Now the provided further. This is amendment has come in the 2017 that gap has also been whether every teacher appointed or in position as of the 31st March 2002 and who does not possess minimum qualification as laid down under subsection shall acquire such minimum qualification within a period of 4 years from the date of commencement of the right of children free and compulsory education act 2017. Then this is the
So it used to be counted from 2017 for a period of 4 years.
No.
No, 31st of March 2015.
First April 2015. With the retrospective
Provided further that every teacher appointed or in position as on 31st March 2015
March 2015
who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years.
That means from 15 to 4 years.
15 to 4 years. 19.
19. That is a retrospective effect was given because in the gap that your lawsuit has seen that section 20 that 5 years were there first. There was a gap. This gap has been fulfilled. Therefore, this provision really speaks about the person
In-service teacher.
In service. In service means service.
It does not relate to fresh appointment.
No, not to relate to fresh appointment. Service, in service, and that is service means this recognized service. Recognized service. Your lordship will also I have asked my junior to bring the notification regarding the primary teacher. What has happened? In primary teacher, in 2016, when the notification was made regarding application advertisement itself was said that the persons who will get the appointment,
yes,
in terms of that advertisement, who will get the appointment, who doesn't have the training, they have to get the training within a period of 2 years. In primary teachers matter, there the advertisement clause is there. Because I am arguing that matter. That's the I know this distinction. Here it has been said, teachers who are in service. In 2016.
So this avenue is not open so far the fresh appointees are concerned.
No fresh appointees.
Which is there in case of primary teachers.
Yes, that is the distinction. I will show the advertisement I have brought it. I have brought that. That is a distinguishing para-teacher here and in this case and the primary teachers in 2016.
They are not similarly placed.
Not similarly. So that is one of the points we are arguing there. What has happened, Justice Ganguly said, there is a demarcation, untrained and trained. And then went on trained is totally wrong. Untrained is wrong. Effectively, I tell you, even the board did not answer the point. But this advertisement, when I came to appeal, I argued this point has been accepted.
So therefore, this relaxation based on section 23(2) second proviso is not open to all.
Open to all, only those who are in service. Even
Thereby granting them opportunity to acquire qualification as prescribed under 23(1).
yes, even my clients, so they obtained this BA degree prior to 2006. If it is not in service, then they
Yes. So the second point which I was saying with regard to that notification which was placed is that it does not apply for recruitment processes. It applies for in-service teachers. What they are trying to make out is that we are in service because we are para-teachers. Firstly, we are saying that no para-teacher is not equivalent to an assistant teacher. And secondly, even if we take it that yes, you are equivalent, then that 2-year relaxation or 4-year relaxation for acquiring the B.Ed is for protecting your service as a teacher, not for participating in a selection
Why
process.
advertisement, this window was kept open by your commission?
No, if the relaxation, what was actually the relaxation? The relaxation was that
generated hope in the minds of unemployed youth who didn't have qualification but acquired qualification within the period of within the period till 2019 when this relaxation was withdrawn.
the no, there is an answer. I'm just trying to
hear it.
The point is that what your lordship is saying, that that's the reason I have picked my notes here.
In the morning, Mr. Bandyopadhyay was appearing for the commission.
In this matter also, actually, the selected candidates
Yes,
are,
that I know.
so we are on the same side at least.
Certain extent I will argue.
Mr. Bhattacharya is in practically on the other side.
The clause was the minimum qualification as prescribed by NCT.
Where from you are reading?
It's fine, it's advertising. Page 170.
Dr. Patro, tell me the page of your advertisement.
Advertisement is annexed.
Yes,
194.
Page 194.
192. Can you see? No.
Just a minute.
Note to schedule 1.
194, note to schedule.
Schedule 1.
This is 23rd September 2016 notification.
Oh, sorry. The note to schedule 1 on the
2016 rules.
Page 180.
Yes, 178. It starts from page 178.
Page 180.
Yes, rule 4.
Schedule 1, 8, subject 4. There is 10%.
Just a minute. Note to schedule 1. Yes, schedule 1, then note, yes.
The minimum qualification as prescribed by NCT and relaxation of qualification, if any, extended by the central government from time to time. If any. Then if any, you have to read with the 23 proviso, second proviso. The problem has been created. Of course, we are having the argument must be clear. There's an advertisement clause. Page 190. Yes. Both trained and untrained candidates.
194.
Yes.
Yes, this is the recruitment notification.
Clause 2. Yes.
Clause 2. Both trained and untrained.
Untrained candidates are eligible. Then kindly come. That will more clear. Kindly come.
That Mr. Bandyopadhyay should not have been.
No.
In view of 23 second proviso.
It doesn't. It should not have been there. It should not have been there. But later, we have to make a harmonious construction of the kind. Clause 9
Of the recruitment notification.
Yes, not with clause 9. The 9, both
Eligibility.
both trained and untrained may apply, and untrained will get preference, but only when trained candidates are not available. The only untrained candidates will be considered in compliance with the order of Honorable High Court, Calcutta.
So that is the case of some of the petitioners, that vacancies are available even after accommodating trained candidates.
That's, well, I have nothing to say out there. I am not for anybody's. Let me take it.
Because your purpose is served if trained candidates are accommodated. Yes.
But the point is, another two provisions are there. Clause 10 certificate received up to the last date of the application.
Where from? Where from?
Page 200.
Page 200.
Page 200, can you change surplus 5?
Just a minute. Yes, page 200. Age limit is 5. Provided certificates.
Certificate received up to the last date of the application and mentioned in the application form shall only be counted for academic and professional qualification. Right? Then all academic and other certificates received and informed as on the last date of application will only be accepted. All academic and other certificates received and informed as on the last date of application will only be accepted. Your lordship may be confronted, all we may be, I not saying court, all we may be confronted with advertisement cause some confusion, something is there. This, if we read one by one, if there, but nothing should prevail over the act itself. What they have not done, it should have been done, that they would not have
included.
No, they
permitted
untrained candidates. No, they would have challenged the advertisement. They are participated. They are participated, and then come. Therefore, this is.
But that theory after participation will not apply, because here the commission is saying since you are untrained, you are not eligible. Now you are not eligible.
Yes,
in view of the judgment of the coordinate bench.
Yes, already it has been held. Rather, leave aside that we are confronted with the question. We are confronted with the question whether the court can. That a court under Article 26 can go or can pass any order contrary to the statute. Leave aside advertisement. Leave aside advertisement. Even the advertisement give a liberal approach. If the questions comes before a lead court to decide, but no mandamus can be issued against a statute.
And the problem was created due to this recruitment notification. That is contrary to the
itself section 23, second provision subsection 2. Absolutely. What has happened that time in the country itself? Since I participated in that debate, I read that now it is
the purpose of section 23 is to second provision to subsection 3 is to give opportunity to the in-service candidates to acquire required qualification.
I'm just now iPad facilities are there. Now I am keeping every of my discussion etc. in this at that time, because what has happened all over India, statistics which were given, the statistics shown that the trained candidates are very few. Untrained candidates are. Although 2009 statute has come, but the problem of our country is that I put it in other level. In our country, all fields are covered by the statute. Implementing agency is the government and not the agency, but governmental agency. They don't implement it properly. Now, therefore, the problem popped up in the country.
As it has happened in case of school service commission.
School service everywhere, not only here, everywhere, every state. And there were so many requests had come to the central government. We are considering this. When they have given, I made also my research on that. That every state.
See the dichotomy. Mr. Dr. Patro is relying upon Section 4, Rule 4. At the same time, he has to also give a clarification with regard to the untrained candidates who are permitted to apply.
Okay. That was a stage, was a very confusing stage was there. Thought it that we would get, but there after this proviso, it has been made very clear, very strictly clear. And last one, 2021. Oh yes, last one was issued 2017. In this 2017, time was extended up to 2009. That is the extension was done. Last one was done.
After 19, there was no.
That time I remember that the Shukri was the HRD minister. I fully remember. And he in the floor of the parliament has been very clear. Yeah, we are giving last time, all states. If you obtain, if you don't, we will not do. The benefit will not be given to any states. Any state. City then that time was the HRD. I can remember that.
You try to finish it up today. So that on the next date I can hear Mr. Wandawad. Yes. Yes, the today matter is not going to be concluded.
Running so many.
I am telling you this matter is to be fixed after vacation. Yes, because it's a motion bench. It's not and you know what is happening in the morning. All of you know.
Will it be possible to fix up on 6?
What is in my mind, I am telling you that November. Nowadays, you know, hardened part is
no, that they need to be great difficult. This matter, everyone. This matter will.
This is a genuine case where it has been heard.
Yes, I have heard substantially.
Extensive.
And just suggestion. Your lordships can also say these matters have been successively argued, etc., etc. Only one person has left all arguments. Your lordship can stop there also. You do not right. This expression part, the hardy part, that is enough. We can take steps. On principle, if your lordship doesn't do it, I will not say. But it has been hard extensively on several days, and this is almost they have completed argument. Only one argument is required.
Yes.
Develop this.
Yes, Dr. Watson.
Only one thing, that is the advertisement which created the confusion, if we put it in that. That was challenged, and that was the outcome of the judgments which I have just placed. Justice Bhattacharya's orders, that was the challenge, that whether trained or untrained, both can be allowed.
That was the main issue before the coordinator.
No, there were several issues, as I all mentioned there. One of the points was trained, untrained were being included. So this was
that you have demonstrated.
Yes, so that
the
was
relevant part of the order passed
yes,
by the coordinator bench.
So that has been adjudicated. So the fact that the rule is there
and against which no appeal was preferred,
no
but
appeal.
This part was not.
No appeal. No appeal. Not a single appeal. Basically, that order was against the commission because our selection process got set aside. But we also did not file any appeals.
No, 90%.
We carried it out. We accepted it.
90%.
So this issue covers 100%.
No.
It has been carried out, yes.
This issue covers 100%. No use saying from the side 90%, 90%. This be trained, untrained is for the 100%. Your parateacher qualification for that 10%. Whether you are genuinely fulfilling the requirement of a parateacher, that only for that the 10% is there. For being trained, untrained, 100%. All candidates are to.
This recruitment subject to correction, is for the para teachers, 10%.
Yes, but the judgment of the coordinate bench includes a para teacher and 90% open category candidates.
Judgment concerns 90%. Judgment concerns does not concern para teacher.
Let my learned friend show that the judgment says 90%.
90% plus 10%. Otherwise, in connection with the same selection process, why different parameters will be set?
The 8.4 rule your lordship has been invited to. Then is page 194, the advertisement.
Just to
194. 194.
Yes, 194.
One advertisement, one rule.
Same notification for
everything.
10% and
yes,
90%.
yes. They got segregated. They would not have got segregated. They got segregated because of a challenge with regard to who will be considered a parateacher. So Samprasharoks wanted to be parateachers. They were not allowed.
We had to adjourn since the issue was.
So we submitted that for just 10% reservation, please do not stall the entire selection process. So it got segregated. And in this 90% also, there was no bar on the parateachers. Those who have above the cutoff without parateacher reservation, they have been selected. This is only for the reserve. Those who are below the normal cutoff, but have parateachers.
90% of the vacancies covered. 10% of the total vacancies, my lord, are restricted for these sort of teachers, para-teachers.
Yes.
10%.
Yes, that is the situation.
My lord, please see 8.4.
Very well. Otherwise, it will never end. Let Mr. Dr. Patro complete his submission. No piecemeal hearing in this fashion. Yes, yes.
So this issue.
So therefore, the decision of the coordinate bench, according to you, is applicable in case of 90% and 10%.
Yes, yes, yes. Same rules, same advertisement. As far as this point is concerned, trained, untrained, this will apply uniformly to all categories who have participated in the selection process.
Yes. 10% vacancies.
10% vacancies reserved for parateachers.
We are concerned with that
Yes,
selection.
yes.
Yes.
Petition
To that extent, there is no quarrel. Yes. Yes, yes, yes.
Yes. Now the next issue is that after the court finally decided and directed us to start again from the stage of Rule 12.2 onwards, again there was series of litigations. The litigations went into.
Now, when the court directed to start again from 12.2 stage, whether it was confined to 90% or 90% plus 10%?
90%.
That I will have to check whether the court had bifurcated on exactly which date the leave was granted for us to proceed separately. But this point will cover all.
There are several lanes and by-lanes.
No. Let me put it in a different way. This is
me for interrupting. None of the petitioners here in either side My lord, even Mr. Singh's petition.
Uploaded,
petition.
uploaded testimonials. Motion.
No, my lord, none of the petitioners were a part of that 90% selection process. None of them, subject to correction by you.
Then under which
None of them.
selection process? I am
They
asking
were
my.
part of the vacancies of
I am
10%.
asking that after the direction of the coordinate bench to start the process from 12 to stage.
90% selection.
Whether
process is over.
this selection process was carried out in terms of the order of the coordinate bench for 10% plus
No,
90%,
not for 10%.
or for 90%.
Only for 90.
Court did not mention, and I have already just submitted those para teachers who were above cutoff. They have participated. So that means they have uploaded. So now we need to scrutinize whether these 200, 300 candidates who have filed these writ petitions, whether they uploaded or not. We will not go by their word. Then it should be checked. Because it is the same selection process, the same advertisement, the same dates were being followed. You made the same online applications. There was no segregation. Segregation was only for the fact that 90% should not suffer because there is a question with regard to 10%. It cannot be segregated. It cannot be said that it is a separate selection process. Or else the rules would have been different. We would have given a different advertisement. Let me give it just a.
So both the selection process emanate from this recruitment notification,
Yes.
which is at page 194.
Yes, they cannot deny it. This notification is the notification on the basis of which 100% applied. On the basis of this notification, 100% made their online applications.
Yes.
Para teacher is a reserve category. They cannot claim anything beyond that. If I say, for example, caste reservation, can they say their selection process is a separate selection process? It is within the same selection process.
Yes. Go ahead.
Now the second round of litigation started. And again, the same questions were being brought up. Again, the question of B.Ed, non-B.Ed was also being brought up. And it went all the way up to the division bench. The division bench decided the matter. The division bench did not utter a single word in the judgment while finally deciding the...
I was part of that division.
Yes, at one of the orders, my lord also had read. Now, the final... So it is very difficult for me to show from the division bench's judgment that the division bench held that yes, untrained teacher candidates are not allowed to participate because there is no whisper, there is no mention about trained or untrained. In the entire judgment, as far as I have gone through it, there is nothing there. But
therefore, the observation of the coordinate bench remains unaltered.
Yes. Now, what my learned friends have argued, that since the division bench did not pass any comment with regard to trained, untrained, then it should be held that that point is still open. And the single bench may hear the point. Here also I am objecting it. After arguing, if the court does not make any comment with regard to either the arguments or the prayers made or grants any kind of relief, it is to be held that the court did not accept any submissions made, and therefore the court was not impressed by the submissions, and therefore no order has been passed in your favor. You cannot presume that that point is still untouched, and I will come back. From the division bench's judgment, the only reason why I have brought it is just to show the court that their matter of trained, untrained candidates was also before the division bench. Just kindly see the division bench judgment. Again, para teacher, upper primary issue, the same chain of litigation. The second round, division bench's judgment. No. The second round litigation. Division bench, যেটা এখন যেটা দিয়েছে court. See page 40. My lord will kindly first see the first page.
Yes.
My lord will find that I think about 36 cases were heard together. The second case, FMA 1233 of 2021 on the first page.
Yes.
This is Devashish Modi and others versus State of West Bengal and others. Their case, along with 11 others, a total 12 cases were filed, all with regard to we are untrained candidates, we are to be permitted to participate. Court did not make any observation. Now, kindly just see page 14.
So this 1, 2, 3, 3 relates to untrained candidate.
Yes. Now, kindly just see page 14. The first set of advocates. For the appellants in FMA 1233 of 2021,
yes, page 14.
They were represented.
Yes.
Now, from the names, nothing transpires and the judgment does not reflect anything, but I have brought the single judge's order which was passed.
This appeal was carried out against the order passed by the coordinate bench, Justice Bhattacharya.
No, Justice Bhattacharya was accepted. We restarted the selection process. Numerous writ petitions were filed, and then ultimately 36, after disposal, they were moved before the division bench. They went up in appeal before the division bench. So it is the second round of litigation. Like the second round of selection, the second round of litigation started. In that, the division bench is ordered, not from Justice Murshumi Bhattacharya's. Murshumi Bhattacharya's judgment concluded the litigation as far as that round was concerned.
This is at the 12-2 stage when verification started, then several petition, several litigations generated, and then this appeal was.
All
division bench considered this appeal.
Yes. Now just kindly see the order. Though actually not on merit, the writ petition was dismissed. The first page, the very last line, in paragraph 11, they have stated that they are untrained candidates.
So since the petitioner did not approach the commission, that's why it was.
Yes, the court did not decide, but they did not approach the commission. Instead, they have gone in appeal, and the appeal court has.
This is the appeal.
Yes.
This is the
Devashish Modi, the second matter in the list of the judgment which I handed up.
That 1, 2, 3, 3.
Yes. And the fact that it was argued, it is not that that case was lost in the crowd of submissions going on. They had even filed their notes of arguments.
Division bench did not make any observation.
No, but just to show that the case was moved and argued, they had even filed their notes of arguments that I have brought, but I do not have an extra copy right now, so I'm not able to show it. So as far as two things, as far as the litigation part is concerned, according to me at least, this case cannot be further argued. It is more or less decided, though not in so many words. The fact that untrained cannot participate, that is more or less decided as far as the court cases are concerned.
Yes.
Now, following these judgments, the single bench of this court has passed repeated orders dismissing candidates who were untrained. That bunch of orders also I have prepared. আমার মঞ্চটা কোথায় যেটাতে
I will record that in Siddiq Sardar you have concluded yourself.
We'll be giving reply.
Yes. Yes. Anything you want to add?
My lord, two things I would like to place, but out of which one I will request the court to allow me to place it on the next day, because that is with regard to the NCT, their stand. One affidavit they had filed in the Supreme Court that I found it while searching all the papers, and my submissions with regard to the notification they had produced with regard to the extension that I have not.
Extension of?
The relaxation. So
after 2019, there was no
extension. No, that is the final. But the fact that
in order to substantiate your case,
yes,
connection with the recruitment notification of 2016.
Yes. That point I would like to argue on the next day after a little more going through it. Today, the only point which I would like to place it is.
On any affidavit, if you can disclose it to us. This NCT affidavit or whatever.
That at the time of placing, advancing this argument, it will be supplied to you.
Not in advance.
No, if it is after vacation, I will try to prepare a set and I will give it to everyone.
Prepare a short note.
Yes.
During vacation.
Yes.
Short note.
My learned friends will remind me. The only last thing is to sum up the litigation part. That is now following all these orders of Justice Moushumi Bhattacharya and not the division bench in that sense. Court has passed multiple orders, most of them by my lord, rejecting the prayer that the BEds acquired subsequently. They have
those orders, please do not place it. The matter is being heard in open mind. Take it back. Because the dimension gets changed.
Yes.
In the meantime, after elaborate.
Yes. So that also, as I am also preparing.
The open mind has to hear this.
Yes.
Now, don't invite notice of my order in similar other matters which were passed previously. That may create difficulty.
But one I have annexed to my affidavit in opposition that will remain in the record. But possibly that is not my lord's order.
I remember that on BEd I had passed some orders that may have gone.
One order of Justice Basu is annexed. So very well. It is in the mind of the court. Court is.
Yes.
Court will all. Then let
once this qualification, BEd qualification is stipulated in the recruitment notification and which is backed by Rule 4.1 of your 2016 rules.
Yes.
Then at first blush it comes to the mind of the court that how untrained candidates are able. So on this premise, these orders are passed. Now today matter is being heard and new points are being argued. So these are required to be considered by this court. So
We are trying to strengthen the thought of the court that those judgments are all,
Previous orders passed in this.
the previous
After,
orders are
who
all,
knows, after passing this, delivering this judgment, it may appear that my previous orders were wrong orders.
and 90% will be in tears.
Yes.
Anyway, let us come back.
Item 25 is slightly different, my lord. There, my lord, the petition already, my lord, having the B.Ed qualification in 2007, and my lord, only due to technical glitch, my lord, could not, my lord, the upload it at the
Same thing, you are coming under the ambit of Justice Mosmi Bhattacharya's order, where it said by omission, if this is not disclosed, they are not eligible.
I was having the qualification on the last week of application.
Order sheet দাও তো কতগুলো order কি হয়েছে তো দেখুন মানে before vacation তো আর নেওয়া যাবে না order গুলো
The cases where there are minor differences from the main case that I will indicate on the next day.
in your
Second-
written notes you indicate this.
Very well.
সিদ্দিক সাদ্দারের বিটটা এইটা হ্যাঁ 21077 But where is my last order? 13 May পরে আমি শুনেছি মনে হয়। What was the last date of hearing this matter? 13 May? দেখি দেখি দেখি। Yes. হলো তো? না না এটা reference file. Where are the other orders? 14th August. দেখি order গুলো কোথায়? ওটা সিদ্দিক সাদ্দারের উপর তো অর্ডার গুলো হচ্ছিল জেনারেলি এই ধরনের কিছু একটা আলাদা অর্ডারের একটা ফোল্ডার রাখবে 21000 ওই অর্ডার গুলো লেখা আছে এখানে 28 August last আরে এই ফাইলটা অর্ডার হচ্ছে এটা matters are hard জানি matters are heard on number of occasions. Hey. In WPA 21077 of 2023, Mr. Bishop Bhattacharya, Learned Counsel, representing the petitioners, has concluded his submission. Stop. Dr. Shutanu Patro, that's correct. Dr. Shutanu Patro, Learned Counsel, representing West Bengal Central School Service Commission, has made submissions. Stop. Added respondents are represented by Mr. Kullan Bandyopadhyay, Learned Senior Advocate. Stop. State respondents are also represented. Next paragraph. List the matters under the same heading for further consideration on 6th November 2024 as 3 p.m. fixed matter. If there is change, take steps if you want. Yes. That's why I have indicated.
to file. Yeah.